Ban. CABAN.
Oh, we got one Spanish case the clerk wants to do, although
I don't have any of the matters this morning, so whenever you call my case is when I'm available.
oh, okay, I thought you were really in a hurry based on your body language,
No,
but
no,
maybe
no.
that's just normal. Okay. One interpreter case? All right. This is Mr. Velazquez Lopez, I believe. Thank you.
Good morning, Your Honor. This is Alan Figueroa, State Certified Spanish Court Interpreter.
Thank you very much, sir. I have one case for you today. It's Mr. Velazquez Lopez, case number 21CF5892AO, Division 15.
Sí.
The
Okay.
defendant can hear me, Your Honor.
Was that a question?
No, I'm just letting you know, Your Honor, the defendant can hear me. I've already
Right.
established connection with the headset.
Got it. Thank you. All right, I'm not seeing a public defender application, sir, but you are certainly at liberty to fill out a public defender, and in fact, we generally appoint the public defender just in case you need one. And the allegations are aggravated assault, commit a felony, and also you have a related misdemeanor, which is from the same allegations, 21MM193. Sir, since the alleged victim is not here, we normally have to require no contact, separate residence for now, until a judge can hear from both sides and determine that it's safe. I know you live together, so if you need a police escort to get your things out of the residence, that will be provided. In regard to seeing the kids, sir, generally speaking, arrange that through a third party. And also, if Department of Children and Family Services gets involved, which they generally are referred to these circumstances, then you would follow any orders from Department of Children and Family Services or the juvenile court judge.
Okay.
Counsel, I think the paperwork says he meets pretrial release authorization, even though it was alleged to be a kitchen knife. I'm not used to that. But is that normal?
Your Honor, if PTR says he otherwise qualifies, he otherwise qualifies. I'm not always completely sure about their qualifications. And what
Yeah.
doesn't.
Just want to do the double checking on that, right?
Yes, Your Honor. Given that he otherwise qualifies, state wouldn't object. However, I would ask for a monetary bond in conjunction with the allegations that are in the affidavit.
Okay.
Okay.
I believe there's a rather hostile relationship between the victim and the defendant. And I don't believe the defendant is a U.S. citizen, so granting bond in conjunction with PTR will just help secure his, him coming back to court to deal with these cases.
You're asking for bond and PTR?
Yes, Your Honor.
Counsel?
We feel that the PCR would be sufficient along with the no contact order as there's no victim present. Mr. Velazquez Lopez is employed full-time. Misdemeanor 9 years ago. There's no criminal history here in Florida or out of state. PCR should be sufficient along with the no contact order.
Okay, just asking the jail staff, does he meet the PTR requirements?
Yes, Your Honor. Charge qualifies. We don't ever look at the details of the affidavit. As long as the charge qualifies and we have all the information we need to supervise them, they qualify.
Okay, so if it was an assault with a knife, would it still qualify? Yeah, okay, well, that's a little different from what I was used to back in the day. And I understand the state's concerns and objections in regard to the other allegations in the relationship, sir. Now, women generally don't expect to be treated like that anymore, you know, in regard to being a servant. I mean, that's from a whole nother century, okay? But I will go along with the pretrial release on both counts, other requirements. Don't have contact with her until you guys get before the judge and make sure it's all safe. And you talk to your lawyers about setting that hearing. If you have any guns, knives, or weapons, put those in the care custody of the arresting officer within 24 hours of your release. And I told him to comply with DCF. Good luck, sir. Thank you to the interpreter.
Your Honor, before I disconnect, may the interpreter get the case number for the misdemeanor 21 MM?
Yes, sir. 21MM 193AA.
Thank you, Your Honor.
You're welcome. Thank you.
Got all the conditions.
I did, okay. It's,
Coming back to you.
well, it isn't even so much that I forget, but some of them, you know, the just say no stuff, I just think it's futile, although I understand why you're asking for it. Okay, so is this Mr. Caban, this case? You
Good
do?
morning, Your Honor. Please the court. Frederick Trable on behalf of Mr. Caban.
Let me barcode it real quickly. All right. I guess it's out of Seminole County, 2020. Is this a CF 233? I'll find it. It's down here somewhere. And to the side, did you put it to the side? Thank you. All right, so it's in this stack. All right, got it. Go ahead, Mr. Treben.
Your Honor, this time I'd ask the court to give Mr. Caban a bond as to the two offenses that are alleged here in Orange County, the violation of conditional release, and then the driving while license suspended. I'd ask that both counts be no more than $1,000, Your Honor. I've spoken with his family members. They have the resources and the funds to procure a bond for $100 each to a bondsman. They've already contacted Moncrief Bail Bonds. I'd ask the court to take no action other than just leave the hold, and we'll go to Sanford Diligent Matters in Seminole County.
Okay.
And by the way, it's good to see you again, Judge.
Yeah, thank you very
No
much.
problem.
Same here. Where is it? Let's see here. We got the driving while license suspended. That's 21 CT 3648AO in Division 81. All right, so why did he put that no bond? Just because he got the hold?
Yes, Your Honor. If I had to guess, Your Honor, no bond on a duelist,
Oh.
just to make sure the Seminole County holds came through, which is, in all candor to the court, Your Honor, understandable.
Okay, all right. All right, I'm not seeing the driver's license record, and so I don't know that there's anything significant about that. The state's not concerned about it one way or another?
Your Honor, I don't believe he has any prior dwellis convictions, so I don't believe his driving record is too terrible. I don't have access to it right now, though, so I just asked for a standard bond on the dwellis.
Your Honor, we're not
About
contesting
$500
probable cause. I just want to make sure, and I understand the court knows that, you know, that it's not a PBL or a BOP. Just want to make sure he sees a bond. That's the only reason I'm here, Your Honor.
All right, $500 bond on the traffic case, and that's all we got here?
No, Your Honor, there's a second case and a contempt of court case.
Oh, what's that? Failure to pay fine.
Yes, Your Honor, I believe it came in as a contempt of court. It's basically a violation of pretrial release
Oh, because of seeing,
out of a Seminole case.
You know,
ironic. Okay, so why we would, okay. Oh, all right.
Your Honor, state would ask for 1,000 on that one. Counsel's already testified that
All right.
the defendant can pay for 1,000 on both.
All right, 1,000 on the domestic. and 500 on the driving while license suspended. And it says contempt of court, but it says Seminole on it, so, but go ahead and bond out, and your lawyer will clear up the details of which case is supposed to be in which county.
Okay.
All right, thanks.
Your Honor, unfortunately, I don't have any other matters for this court. I wish I did. It's great to see you. Taking me back reminds me
Yeah, yeah.
how lucky I was to be mentored by such great county court judges such as yourself and Judge Miller and Judge Clark and Judge Morgan. But this is the only matter I have before this court. With your permission, Your Honor, may be excused.
Yes, sir, thank you very much. Yes,
I just want to let you all know, Seminole County did come off his bonds from a felony case,
Uh-huh.
so he does have those bonds. They did a bond surrender.
So is it a hold or?
It's two holds for them. It says a bond surrender, one case for 5,263. It's a 2020 CF 2332 case. And there's another one for $5,000 for a 2020 CF 2201 for Seminole County. Battery by strangulation,
Yeah,
so that,
So the surrender still leaves the hold and gets transferred, correct?
yeah, because I believe if he wanted to post bonds on those, we will have to get in contact with Seminole to see if he can.
I think they're gonna transfer, they'll probably just put a hold on there, but, we'll post the Orlando bonds and deal with them as they come through.
okay, good luck, nice to see you.
Always good to see you, Judge.
Okay. All right. Is this Mr. Leo Britt? Right, okay. Okay, sir, this is case number 2021 CF 541880, and we can appoint the public defender, sir. It was a warrant, an arrest warrant in regard to an allegation from May 7th, alleging a number of counts, including count 1, kidnapping, count 2, battery with 2 priors, count 3, aggravated assault, count 4, false imprisonment, count 5, witness tampering. And it appears they have at least probable cause to file those. Or at least arrest you on them at this time.
Your
Are you
Honor,
standing up for a particular reason?
yes, Your Honor, state would ask that you hold a no bond on count 1, given that it is a PBL.
No argument, Your Honor, though pending a evidentiary hearing downtown in Arthur hearing.
Okay, all right, well, okay, that's fine, it's Division 10. Then, do you want me to bother with his subsidiaries? I mean, usually I do some work and say work downtown, but you're going downtown anyway, I guess.
Yes, Your Honor, I'd ask that you set bond on 2 through 5 as he is otherwise entitled to it.
All right, say 150 on count 2. $150 on count 3, 150 on count 4, and 150 on count 5. Sir, they're going to take it downtown for a real bond hearing. In the meantime, no contact with, I think it's the girlfriend in this case. You can't like call her and try to tell her to drop charges or anything. Good luck.
Okay, thank you.
You're welcome.
So, Your Honor, for the record, that was no bond on count 1.
Yes, ma'am. Thank you.
Thank you.
All right, this is case number 2021 CF 31180. And let's appoint public defender on that, Mr. Houghton. So the allegations included basically 4 counts of child neglect and 1 count, count 5, battery domestic. And we have the witness here. She's already been sworn in. Ma'am, would What we mainly want to know is whether you want to have contact and whether you feel safe or not in the state.
Of
Likes
course,
to
I
ask
feel
those
completely
questions.
safe. Yeah.
Okay, all right.
May I inquire, Your Honor?
Yes, ma'am.
Good morning, ma'am. Can you please state your name for the record?
Carol Mullen,
Can you please spell your last name?
Mullen, Molen.
Thank you. And what is your relationship to Mr. Houghton?
He's my fiance.
Approximately how long have you known him?
6 years?
Are you afraid of him?
No, God, no.
Do you want to have contact with him?
Yes, I do.
Has anything like this ever happened before?
No.
Are you willing to call 911 if anything like this ever happened again?
Yeah, but it would never happen. That whole night was a mistake, and they had gotten a statement from me when I was extremely intoxicated, so none of it was true.
Okay. And do you believe drugs or alcohol played a part in this?
No, mm-mm.
Okay. And the children that are alleged in the affidavit, are they both of y'all's children?
Yeah, we share 2 children, and then 2 children is his other baby mama.
Okay, thank you. That's all I have, Your Honor.
Okay,
No questions, Your Honor.
all right. Thank you, ma'am. You can stay there if you want to listen to everything.
Okay.
Okay. All right,
Your Honor, the state would just ask that you stay the bonds on 1 through 4 instead of reasonable bond on 5.
okay, the only thing about the 1 through 4, I understand, they're the typical bond for each count instead of the subsidiaries. That could add up quite a bit, and it's basically the same incident.
He has been employed full-time at the same place for 20 years as well, Your Honor. I think a monetary bond should be sufficient on those counts.
Okay, just regard me as an old person with a hard of hearing. I've got a printer going on up here and all kinds of stuff.
Well, I think if I speak from here,
Right, if you speak in the speaker, and the mask doesn't help, so, but, all right. And also, given the circumstances of the family with living in a 2-room situation, they're not rich, so we'll take that into consideration.
Your Honor, I would just point to his history.
Yeah,
He has
and,
several batteries, prior child neglect, prior bat DVs,
Yep.
prior violent history.
yep. Okay, so, I do have one question, ma'am. I imagine that the Department of Children and Family Services has gotten involved.
Yes.
All right,
We're working on our case plan now, and he's already started the domestic violence classes. We're doing everything we need to.
all right, so that'll be part of the requirements.
Of course.
Okay. All right, so we'll find probable cause, although I don't want to minimize these circumstances at all, but I'm a little bit concerned about the financial capacity of this family to provide for the children. And I assume you're the one who's going to bond them out. So not to minimize anything, but to accommodate the needs to feed these children,
Of course.
I'm going to set the bond on count 1 at $1,500, and the other, count 2, 3, 4, at $150 each, and $100 on the battery. That has nothing to do with the, importance of the charges, but more concern about feeding the children. And then the requirements are, state any objection to no hostile contact with her, but
Not with her, Your Honor, but.
all right,
the
so in
children.
regard to the children, how about we require him to follow the orders of Department of Children and Family Services and/or the juvenile court?
Your Honor, generally in circumstances like this, what I would ask for and what the court would order would be no unsupervised contact with the children until DCF makes a different determination.
Well, so, yeah, that would be,
Hold
I
on.
think, almost the same thing, because DCF is already making the
Exactly.
determinations, and they're already involved in following up on those. So, I'm just going to assume she's correct, because this allegedly happened a little while back anyway. Follow Department of Children and Family orders and/or juvenile court orders. And let's say no drugs or alcohol, because, despite what she said, it seemed like that was involved and is a problem. Come back to court for all your court hearings and public defenders appointed. It's going to Division 10.
Your Honor, Sue would also ask for no weapons as it is a felony.
Right. Any guns, knives, weapons have to be surrendered to the arresting agency within 24 hours of your release. Good luck.
Thank you, ma'am.
Yeah, no hostile contact with the young lady.
Thank you.
You're welcome. Is this Mr. Johnson?
Yes, ma'am.
Thank you, sir. We have the new case is 2002-1 CF 509080. It's going to Division 19, and we can appoint the public defender to represent Mr. Johnson. And we have a witness previously sworn. Could you tell us your name for the record, real clearly, because I have trouble hearing?
Carrie Johnson.
Thank you very much, Ms. Johnson. What was it that you wanted to say in regard to safety and what it will be, what you need in order for safety to occur?
Okay, I come here today to clear up an incident that happened at my house.
Right.
One of the victims,
It happened between the two sons, right?
yes, and
Okay.
I'm the grandmother that raised them too.
You're the grandmother, okay.
Yes.
All right, got it.
And what I'm coming here today, and I brought a letter from the grandson because he couldn't be here because one of the kids got sick, that he made up a story, and I apologize for it because I teach them better than that, to get along with each other. So he made up a story just to get revenge on the other brother, which is wrong. But he wrote a letter, and I brought it down here today because it was at my house, and I witnessed it all.
I don't have any real business get involved because I'm just the umpire here.
Yeah.
But I think your husband might have said that he heard gunshots too, so that would be an ironic coincidence in
Yeah,
regard to a wholly made-up story.
No. I didn't say it wasn't a gunshot. It was some gunshots, but it wasn't Joaquin. My husband, which is in the car right now, I tried to get him to come in here. He's the witness too as well. Can tell you, it was not Joaquin. It was some gunshots, yes. It's gunshots that happen down in my area all the time. But at that particular day, it was not Joaquin Johnson that did the shooting.
And you weren't there.
I was there.
It-
Didn't nobody talk to me. And my husband was also there. He's here. I
Okay.
can let you talk to him. I tried to get him to come
We
up.
call that
He
hearsay,
stutters.
kind of like, all right, but, you know, obviously there's some issues in this case.
Yes, it
And the
is.
allegations are extremely important allegations, so, you know, I have a feeling we're going to need more than one witness on this situation.
He's in the car. I can go get him.
Your Honor, count one is a life offense. State is asking that you hold him no bond pending an Arthur hearing. I believe this could be better addressed in the trial division when there is an evidentiary hearing, so everyone can
Be heard.
be heard. And it can be an actual subpoenaed witnesses, have the victim present, have all the appropriate witnesses, since Ms. Johnson is saying that there are potentially other witnesses.
Right.
But it is a warrant. There are corroborating circumstances to things that other witnesses in this case said, including a black car speeding away and the gunshots, and then gunshots being found in the vehicle. So I would just ask that you hold him no bond pending an Arthur hearing where this could be better addressed.
Your Honor, given the testimony today, if you are going to hold him at no bond on the charge, you would have to find proof evident presumption great. Otherwise, you can set a reasonable bond for all the charges pending a full evidentiary hearing downtown.
Well, you know, I don't think that one witness, I mean, no disrespect, man, but he also has a really violent history. So, you know, you might be inclined to tell me he's, you know, always been good and everything, because,
I understand, Your Honor, just if you are going to hold him at no bond, you would have to find proof evident presumption great.
I don't have a problem with that finding right now, despite her testimony. Because I do think, ma'am, that when the final determination gets made about what's the appropriate bond here,
Right.
it ought to be a real hearing and,
Yes, okay.
more than one witness on this.
Can I say something else?
Because I know you love him and everything.
Yes.
Yeah,
But I'm here to try to clear up an incident that happened between two brothers.
I understand that,
the other-
ma'am, and I respect your opinion. I'm just saying it's a little more complicated.
Yes.
And we probably need more people in the room just to figure it more out, you know.
I mean, I have the witness that they have on paper.
We already
Yes.
heard that once, and I've got
Oh,
about
okay.
a million
All right.
cases to do, so I'm afraid I'm gonna have
All
to
right.
move it on instead of listen to it a second time, with all due respect.
Okay.
Sir, you are at risk of incriminating yourself. Your lawyer wants to tell you to not say anything and just to let him take it downtown. Going to Division 19.
For the record, are you finding proof evident presumption grade on that charge?
Yes, sir, I'd go ahead and find that.
There is case law that I have that, from the Fifth DCA, that suggests that our client does have still has a right to a full evidentiary hearing downtown to reset that bond.
Absolutely, that's exactly what I'm anticipating, that we have more than one witness, and they give it some time to really unravel this a little bit, to figure it out. We're not saying that you have to stay in jail, sir. We're saying that we want the downtown judge to have a real hearing on this.
Thank you, Your Honor. And our client would also like to request a possible hearing or appearance before a judge downtown sooner rather than later, if at all possible. I know the schedules may not.
Yeah, all I
permit
want
it.
you to do is call the judicial assistant, it's Division 19.
Between his PD and the state attorney to schedule that.
Right, I don't, I'd like to say I could control the other judge, but that, I don't have that authority. But I assume that they do what I always did and grant a hearing within 3 days, which is exactly what I did. It was always within 3 days. All right, and he had a secondary hold.
Yes, Your Honor. I think-
Okay, counsel. He's got another case on 2002-1 CF 53220, in Division 11, a failure to update on a case that he's supposed to be reporting in regard to.
I didn't have the funds at the time to pay for the license with the COVID and no job. I didn't have the funds to pay and go and update my license with the DMV.
Okay, where do I have that? I'll just give you, I won't try to hold you up on that. That's a reporting requirement, but, let's just put a bond of 1,500 on that one. It's another situation for you to deal with.
Your Honor, a condition of that one, state would ask that he report to the sheriff's office within 48 hours of release.
Thank you for reminding me about that. Okay.
What are his bonds on the other charges, Your Honor?
Oh,
Posterity.
the subsidiaries? Well, I guess he's entitled.
Yes, Your Honor, state would ask for no bond on 1 and then reasonable bonds on 2 and 3 and to stay 3 or 4 and 5.
All right. Okay, so in regard to counts 2, 3, 4, 5, all subsidiary felonies, let's put 150 on each of those. And thank you, ma'am.
Oh, thank you.
Your Honor, state would ask for no contact with the victims or witnesses.
All right. So, no contact with the alleged victim, sir, and I'm going to put no hostile contact with the alleged witnesses, since they happen to be his mom and dad, or grandparents, who are alleging that they were in the scene and heard or saw things. All right. And I trust the felony judge to weed it out. Good luck. Is this Miss Kimball?
Yes,
Yes, ma'am.
All right, thank you, ma'am. We have case number 2021 CF 5891. Ma'am, normally we want to appoint a public defender for you because you probably could think you benefit from that. Did you fill out a public defender form?
Ma'am,
No? Are you thinking about getting a private attorney?
thinking about it.
Thinking about it. Well, the lawyers tell me that what they like to do is to have the PD appointed just in the meantime so that they can get the process started where the lawyers are asking for information from the state, and then if you get the private attorney, they just take over. Is that okay? All right, we'll just do that. Because sometimes it sets you back a little bit if you don't get a lawyer involved right away. Okay, so the allegation is hitting his son with the extension cord. I don't see him here today. And I'm just now looking at your criminal history. I didn't think you had any. But
Your Honor,
yes, sir.
as to bond, she's a full-time student at Everest University, to just keep that in mind in your consideration.
Sure.
If you are to set a monetary bond, of course.
Yeah, I'm prepared to set bond now. The state's going to ask that you have no contact with the son, I guess, unless maybe DCF allows, correct?
Yes, Your Honor, I'm going to ask for no contact until that is otherwise modified.
And I was a public defender when I realized that that's against the law. I had an almost out-of-body experience when I realized it was considered child abuse. And it is. I mean, you might have been raised that way. I was raised that way. I turned out okay, although I've probably gone to counseling a lot over time, and it probably still raises issues for me, especially in regard to what I expect from men in my life, okay? So you clearly believe that you're entitled to leave marks on your kid. And good luck, because he's entering teenage years, which is, going to stress you. But DCF is going to tell you to take parenting classes and learn ways of dealing with it without hitting them, because, that's considered quite primitive these days, and there are actually much better ways of dealing with a teenager. Don't say anything. You have the right to remain silent. Anything you do say will be played back at your trial. I'm just going to tell you no. I'm just saying it is against the law, even if you were raised that way, okay? But I'm going to take it into consideration and set bond at $1,500, ma'am, and tell you, we have to say no contact unless and until DCF and/or the juvenile court judge determines how contact will occur. And then you will follow their orders, okay? And this case will be consistent with that. Because in order to comply with the orders of no contact with him until DCF and/or the juvenile court decide, if you need to get some things out of the home because he's 12, we'll provide that for you. If you have any guns, knives, or weapons, put those in the care and custody of the arresting agency within 24 hours of your release. It's a standard condition, you can't have weapons. Did you want to talk to your lawyer first before?
Well, it's concerning the contact. My children already have we have a contract with their father for them to be picked up next week. So they're going to leave anyway for 2 months to be with their father because we have a contract of sharing visitation right. So
This is all standard. When you get arrested for something like this, I have to say no contact except for if DCF and/or the juvenile court maintains the requirements. And so what you're telling me, it'll be fine anyway, they're getting picked up and that's fine, but I have to put these down, they're standard requirements, okay? Good luck, and I recommend those parenting classes. I took them.
I have taken them and I passed them.
Okay, you passed them, well, you need to take them again.
Kids.
Well, 5 kids is enough to drive you up a wall, but you can't be hitting them like that. Good luck.
Your Honor, I don't believe we were appointed, but I just spoke as a friend of the court.
Oh, okay, well, I think what I told her was I was going to appoint you anyway, and if she gets a private attorney, that's fine, they can
Okay.
substitute, okay?
All right, thank you, Your Honor.
All right. Is this Mr. Rivera?
Yes, ma'am.
All right, sir, thank you. All right, in this particular case, case number 2021 CF 5427, it's going to Division 10. Will appoint a public defender to represent you, sir. And we don't have a witness here.
No, Your Honor, count one, however, is a PBL, states asking that you hold him no bond pending an Arthur hearing downtown in the trial division.
There was in relation to a warrant in regard to an incident from allegedly May 9th. And it's being alleged as a kidnapping in relation to allegedly forcing her back into the car.
Your Honor,
Don't say any, are you saying it? I
It's me.
didn't want him to say anything, I'm sorry.
again, if you're going to hold Mr. Rivera at no bond, the state must show proof evident presumption grade on the kidnapping charge. Otherwise, he's entitled to a bond. And even, as we spoke earlier, even if he is held at no bond, he has a full evidentiary hearing downtown.
And what was the that he's entitled to a full hearing?
Yes, Your Honor.
All right, and he doesn't have much of any history either.
Your Honor, I just point your attention to the victim's father did report her missing. And that was later removed once the victim was able to get away from the defendant and call 911, which helps us substantiate this kidnapping charge. I understand the facts of the affidavit.
Yeah, she said she left him because she found her dad to be controlling. And I don't remember figuring out how old she was, because I'm not sure that page, or that was indicated on the, but she,
Your Honor. May I also remind the court that finding proof evident presumption grade is a higher standard than reasonable doubt?
yeah. So, to be honest, when I read it, it may well be, could meet the technical requirements of kidnapping, but it reads more like a false imprisonment charge to me. Ultimately, I think that's how it might be looked at, and I was willing to set bond.
State would just ask for a high bond, Your Honor, so the victim has a chance to be heard at a later time at an appropriate bond hearing. It may, in your opinion, read as a false imprisonment. However, PC has been found for a kidnapping. Therefore, I ask that you set a bond that is in conjunction with a kidnapping, as that is what PC has already been found for.
Okay, I'll let you say something again, but we're getting repetitive at this point.
Well,
I
as to
think
the
you've
high-
already said it twice, and you're going to say it a third time.
Oh, Your Honor, as to high bond, he has no criminal history to speak of in the report, and he's been employed 2 months, which can seem like a long time, but may not be monetarily speaking, for your consideration, of course.
All right, taking in consideration everything and with real respect, I understand all the arguments are completely understandable and reasonable, but I'm willing to set the bond at $5,000 on the kidnapping charge because of it being less aggravated than some of the other things we've seen. And also, he's young, he's homeless, he's been living in his car, he's probably not getting out anyway. 100 on the battery, no contact with her. Sir, there are some aggravating factors here. She was missing from her parents' home. You have no business being involved in something like that. It is a serious aggravator in your situation. You have no business forcing a young woman back in your car and taking her anywhere. And it is potentially punishable by life. Now, you have hardly any history, and that is what I have taken into consideration. You're very young. You might be able to grow out of this kind of a circumstance, but don't have any contact with her whatsoever. If you do, you will come back here, you will be on no bond, and you will not get out, period. If you have any guns, knives, or weapons, put them in the care custody of the arresting office within 24 hours of your release.
State would also ask for no return to the victim's residence.
No return to her residence, no texting, no calling, no Facebook messaging, no questions, concerns, comments through a friend to talk to her about anything, all right? And talk to your lawyers when you get out, so that's it for now. Okay, is this Mr. Santos Pachardo?
Yes, Your Honor.
Thank you, sir. This is case number 2021 CF 588280. Let's appoint the public defender to represent you, sir. They have enough information to file a charge of battery by strangulation, which it's designated as a felony, sir. We see that you're a Marine veteran. You have maybe a little teeny bit of history, and that this was involved in you attempting to, in your opinion, discipline your son. You don't say anything about your case.
Your Honor, state would point to, he does have a prior arrest out of state for an assault and battery
Right,
on a family member,
right.
which under Florida law would be a domestic battery DV.
Okay,
Your Honor, he does qualify for PTRs. He's been employed full-time for the last year and a half, so, and keep that in mind as well, Your Honor.
yes, sir. I just want to clarify with PTR, I always double check, is he eligible?
Yes, Your Honor.
Okay, he is, okay. All right, now, sir, we generally say no contact with the son, the alleged victim, unless or until the Department of Children and Family Services and/or the juvenile court authorize it, and then the orders in this case will be consistent with what Department of Children and Family Services and/or juvenile court determine is what is needed for the situation. And the state might object to PTR, but I think that if you qualify, and then also in particular related to your military service, sir, I would feel safe in letting you out on pretrial release. No guns, alcohol, knives or weapons, put those in the care custody of the arresting agency within 24 hours of your release. And my guess is that the son lives at the family home. And so if you need short-term to have a separate residence while the juvenile authorities are figuring out what the circumstances are going to require, then we'll allow you to have a police escort to get some things out of the home while it's getting straightened out over in the juvenile court.
Your Honor, so you did order that he must maintain a separate residence and one-time return with law enforcement?
Well, I'm going to order separate residence and no contact with the son until the juvenile authorities determine any other circumstances which will make it safe, and then these orders shall be consistent with the juvenile authorities, either the court or the Department of Children and Family Services. All right. Good luck, sir. Okay. Is this Ms. Taylor Crunk? Okay, ma'am. This is case number 2021 MM 338180. And it's an alleged domestic battery. We can appoint the public defender to represent you, ma'am. And I think in this case that Ms. Crunk was eligible for pretrial release. They have probable cause to at least file the charge, ma'am. And I anticipate the state's going to ask for no drugs or alcohol while you're out and being supervised. Or at least no unprescribed medications. And unless the court hears from the other party, we have to start out with a no contact order, separate residence. If you need a police escort to get some things out of the residence in order to comply with a no contact order, we'll provide that. I know he told the officers he was unwilling to prosecute, but he does not have the ability to drop a charge unilaterally. He's got to go through the state attorney's office. It takes time. He's not allowed to tell you to come back to the house. If you do that, you're subject to being rearrested, and it'll be more of a hassle to get out, and then you'll have a subsequent additional charge. So just follow the requirements until you can get back into court, ask your lawyer, or, he can ask the state for a court hearing in regard to contact, but he literally has to come to court and tell the judge it's safe before you can have contact.
He did move out, so I should be fine to go home then, right?
Well, you may need a third party to help you make sure that he's vacated the premises. I'm not concerned with which one of you lives there, only that there's no contact until both of you get in front of the judge and the judge makes a clear and written determination that it's safe. Okay? And the last thing that is standard is that you put any guns, knives, or weapons in the custody of the arresting office within 24 hours of release, because you can't have any weapons while you're out on bond on a domestic charge.
He took the 2 guns that are in my name, so I don't know how I would approach that.
If you don't have any in your custody, then I guess there's nothing you can do in regard to that.
Yes, ma'am.
Your Honor, does Ms. Cronk have a one-time return with law enforcement just to check the residence to make sure he's left? As if she,
That's interesting. Is that a standard?
Your Honor, that's when you say separate residence is a one-time return with law enforcement, you just say you say the condition in a different way that you're allowed to have a police escort. That's what the actual condition is when you order a separate residence, that they get a one-time return with law enforcement.
They can have a one-time return to get some things, but if there's nobody there, I guess,
Your Honor,
or to determine, he's got a different request, which I'm just not familiar with, and I don't know if it's becoming standard, that she can have a police escort to determine if he's vacated the premises, right?
well, my worry is she'll return on her own.
So, well, now, but she could return, she could have a third party check out the residence. See, I'm concerned about ordering police department to go to the house just to see if he's there, which the police officers might not appreciate.
Fair enough, Your Honor. And then also, your bond condition was straight PTR?
Correct.
Okay, thank you, Your Honor.
All right. All right, is this Mr. Azai?
He refused court, Your Honor.
Okay. One thing we've been doing is setting those aside for later. Or you guys want to do that, or you want me to just go through it and appoint the public defender? He's on probation in Seminole County, so he's probably stuck in jail anyway and didn't feel like coming to court.
If appointed, Your Honor, we would waive his appearance.
You'd be what?
When you mean set aside, do you mean reset till tomorrow?
Well, yeah, I've said it later, but we've spent a long time talking about it, so I'm just going to roll through
What
it
she
anyway.
means is we put it to the side until we get through this session, so people aren't waiting in line, and we call it at the end of session.
Understood, Your Honor.
All right, well, I'm ready to go through it at this point. I'm going to appoint the public defender because he needs a lawyer. Find probable cause for the assault in regard to his mom, who's not here. Require no contact with her until a judge hears from both parties and determines that it's safe. And set bond at $1,000 and require no drugs that are not prescribed while he's out on bond. He's got does he have a state probation hold yet?
He does, Your Honor. He has the on-view VOP from
Oh, the on-view VOP from the,
Seminole County.
Seminole.
all right, so what we generally do with that is we just hold him no bond because we expect that Seminole County will come get him. Is that correct?
Yes, Your
Yes,
Honor.
ma'am.
All right, so let's just do that, and I don't really see the court case number for that, but I'm assuming you all have that paperwork.
Yes, Your Honor. In regards to the assault, state would request separate residence, no one-time return, and no weapons.
Right, okay. All of those should be ordered. Thank you. All right, then, is this Mr. Nieves Adorno?
Yes, Your Honor.
Thank you, sir. All right, it's case number 21MM338280. We can appoint the public defender. We have enough information to file the charge of domestic battery because the officer said it happened in front of him, but you don't have any significant history, and I think you qualify for pretrial release, which means you don't have to post bond, but you keep in touch with the jail staff and they tell you what the requirements are. Now, since the other person isn't here, sir, we have to order no contact, separate residence for now until you both get into court and tell the judge it's okay and safe. And if you need a police escort to get, if you have a shared residence, I don't remember hearing about that in regard to the police report, you can get a police escort to get things out of the residence if it's shared. If you have any guns, knives, or weapons, you have to put that in the care custody of the arresting agency within 24 hours, because you can't, 24 hours of your release, because you can't have weapons while you're out on a domestic charge.
Your Honor, there was also an allegation of alcohol use.
So the state generally requests, and I generally go along with a requirement of no alcohol while you're out on bond, since it was potentially a factor. All right.
And that was straight PTR, Your Honor?
Yes, sir. We'll give you the address and phone number to the lawyer's office. Is this Ms. Is this Ms. Rotundo?
Yes, Your Honor.
Okay. Some of these cases might be interpreter cases or something. I'm missing a couple. Okay. All right. All right, Ms. Rotundo, it's case number 21MM339480. They have enough information to at least file the charge of domestic battery. And it looks like you don't qualify for the public defender, although they'll stand by and make sure we don't do anything really bad in court while they're here with you. But you probably might end up getting a private attorney on this?
Yeah.
Okay. And we have the witness here. Sir, were you previously sworn in?
I was, Your Honor.
Okay. The prosecutor wants to ask you some questions, and we can start with your full name for the record.
Yes, Your Honor.
Can you please state your name for the record?
Jason Fenster,
And can you spell your last name?
Fenster.
And what is your relationship to Ms. Rotundo?
Girlfriend,
Approximately how long have you known her?
a year?
Are you afraid of her?
No.
If she were to be released from custody today, would you be afraid of her?
No.
Do you want to have contact with her?
Yes.
Has anything like this ever happened before?
No.
Do you believe drugs or alcohol played a part in this?
A little bit of alcohol.
Okay. If anything like this ever occurred in the future, would you feel comfortable calling 911?
I would.
And I believe she qualifies for PTR, meaning she would be able to get out of jail without posting a monetary bond. Do you have any objections to that?
Not at all.
That's all I have, Your Honor.
Okay. Thank you, sir. I don't have any questions.
Thank you.
This was-
Questions, Your Honor?
Okay. So probably no objections to pretrial release. She doesn't have history.
Yes, Your Honor. No objection to PTR given the victim's input here today and given she otherwise qualifies.
All right, and she might live out of county. Do y'all came up from South Florida or something? But just, you can get released without posting bond, but you'll be contacting the jail personnel who have these requirements that you keep in touch with them and some specified requirements that they tell you in writing. And so it's no hostile contact means no fighting while the case is pending. Please get called again, then you have to come back here on this charge and explain why it was hostile and that, you might have extra complications. State's going to ask for no alcohol because they always do when there's alcohol involved while you're out. If you have any guns, knives, or weapons, put those in the care of the arresting agency. I'm sure that you might not have any here because you really live in Boca Raton.
Correct.
But the standard order is put those in the care custody of the arresting agency within 24 hours of your release, if you happen to have any with you. Or at that, your home county, you'd put, not have any weapons. Make sure you come back for your court dates. If you have trouble getting a private attorney, then let us know.
Thank you.
And when you come back to court.
Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome. Right. Ms. Rodriguez, correct?
Yes, correct.
Okay, ma'am. This is case number 21MM3391AO. They have enough information to at least file the charge of domestic battery. We're going to appoint the public defender to represent you. And, I think it's pretty standard on this one, that she probably meets the pretrial release requirements, but with the standard conditions that, so your daughter doesn't live there, but until we hear from her, like we just did with the last case, and the alleged victim came in and said it was safe and they want contact, until that happens in a courtroom, we require no contact. And if you have any guns, knives, or weapons, put those in the care and custody of the arresting officer within 24 hours. Make all your court dates. We'll give you the address and phone number of your lawyers, and that's.
Your Honor, separate residences and a one-time return?
I don't think the daughter lives there.
According to the face sheet, according to her husband, the alleged victim, her daughter, is no longer living at the home. So I ask that you still just order separate residences. If she no longer lives there, then that shouldn't be a problem.
All right, separate residence from the daughter.
So,
It's just a standard.
I'm sorry, I didn't.
So, we have some standard conditions that we put on every domestic case.
Okay, what is
including
the condition for me?
separate residence and no contact until a judge determines
Okay.
otherwise.
My daughter used to live with me, but she left the day of the incident. My husband requested the police to escort her to go out. So she moved out. She's no longer in my house that I own. Can I go back to home?
As long as she's not there.
As long as she's not there, ma'am.
Because I have a special need child that I need to take care of living in my residence, and I own the property, it's mine.
Right. I'm not trying to just say that she can stay there and not you, just that you have a different place to live from her. All right. All right. Good luck.
Thank you.
Okay, is this Mr. Pelham?
Yes, ma'am.
All right, moving into the traffic cases here. Sir, this is, you have two cases, 21CT3446 and 3646 and 3647. 3646 is driving while license suspended. 3647 is no motor vehicle registration.
And I believe it's just a no valid, not a Willis.
I'm sorry. Oh, exactly. Wait a minute. That's right, there's only two here. I'm not sure what I was referring to on that. Okay, and we can appoint the public defender to represent you, sir. In regard to count one, the normal bond is the $500, and we make the second one smaller at 100.
Your Honor. Your Honor.
Yes, sir.
We do have an offer from the state of adjudication of guilt and credit time served to deal with these charges. I spoke with Mr. Pelham in the back and spoke about the ramifications of entering a plea today, the rights that he would waive. We talked about the citizenship and probationary issues of entering a plea.
Okay,
And I believe Mr. Pelham would like to enter a plea today.
okay. All right, sir. If you wish to resolve it that way, go ahead and raise your right hand to be sworn in, sir. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. Okay, sir, criminal convictions are no small thing. Though you might have had one misdemeanor before. Those are the sort of things that you report on job applications. Do you understand that? Okay. Do you understand all the rights listed on that plea form?
Yes, ma'am.
So you understand you won't have a trial, you won't have a defense, the state won't have to prove it beyond a reasonable doubt to a jury of 6 people, all of whom would have to be convinced that the state proved every aspect of the charge before you could be found guilty. Do you understand that?
Yes, ma'am.
You won't have any real appeal issues because the case will be finished. And as your lawyer mentioned, if you're on probation for anything, it would revoke your probation. If you're not an American citizen, you could get deported for these charges. Any questions about that? Doing this of your own free will? Not under the influence of anything? Satisfied with your lawyer at this time?
Yes, ma'am.
Okay. I find that you're alert, intelligent, entering a plea of no contest in free and voluntary manner. There's a factual basis to accept the pleas. Find, adjudicate you guilty of no valid license in 21 CT 3646, and was it withhold on the no registration? 3647, credit for, is it 2 days time served?
2 days, Your Honor.
Release you as of this charge, and then we put court cost on each one of them, which is about probably $300 apiece.
Your Honor, you withheld on the registration?
I forgot whether you
It was an
said,
adjudication on both.
oh, well, all right.
We would take a withhold of adjudication.
Uh,
Also, I don't believe the credit time was on the record. Credit time.
2 days.
2 days.
We're all talking through the masks.
I know. Sorry.
You know, I worry about these young guys. He doesn't have much on his record. I just want to withhold on it, and I want to talk to him about it. Sir, I know sometimes you just roll through these things and you get to the point where you think you can't pay. Are you attending school at Valencia?
Yes, ma'am.
Okay, so these criminal history, the criminal history can mess with you if you're trying to dig yourself into like a better situation. So I'm going to withhold on the one, so you don't have like multiple more crimes. But you do need to dig yourself out of the hole by going to the clerk's office, getting on a payment plan, or doing something. I'm going to give you a year to work on these so that you do what you need to do to try to get the license back from the other things first. Good luck. You're welcome.
Was I appointed on that case, Your Honor?
Were you appointed?
Yes.
No.
No? Okay.
Well, I mean, what I'm used to is the PDs want to save them another $50 per case, and so I don't.
I understand, Your Honor.
Okay, thanks. Is this Mr. Smith?
Yes.
Okay, sir. We have a driving while license suspended case, and maybe while you were out on bond for a driving while license suspended, or is a failure to appear, is that what it is?
Yes, Your Honor.
All right, case number 2021 CT 656AW. It's in Division 81.
I have license.
You have your license now?
Yes.
That's a good thing. And so the one that you might have been out on bond for was, I think, 2021 CT 551. And the bond on that was 1,000. And the failure to appear warrant is 500.
Your Honor, if he has a license, I believe he has private counsel on the 551 case. But if he has
Did you verify he's got his license back?
I have not, Your Honor.
Is that something we could possibly do without too much trouble?
I would just ask that you set the bond and take no action on the out on bond, so he can be seen in front of his trial division.
I can
Okay.
print his.
All right, well, yeah, that's helpful. All right, so you did not fill out a public defender form. Is that because you had expected to get the same private attorney?
No, I just knew I had a license. I don't know why I'm here.
Well, okay, because sometimes when you get another drivable license suspended charge, I'm piecing things together and guessing a little bit. But what happens sometimes is people get their license back and then they forget that they got a court case that they got to deal with. And they're making an assumption or they forget something about, well, they think that the case is going to go away because they got the license back, but you have to go back to court. Okay? I'm not saying that because I've looked up your case. I'm saying that from experience with what happens with people, is they forget. And forgetting can land you back in here, because if you don't come back to court, they issue a warrant. The only thing the state's asking for is, let's just leave the bond at 500 on the failure to appear, and then take no action on the other one that you were out on bond for. It looks like you got a couple of them, but, yeah, maybe 2 of them that you might have forgotten about.
Can I speak with him briefly as a friend of
Yeah,
the court?
yeah, if you can get out like on that bond, that'll solve the problem, and then you just. Thank you so much. It's been a while since, sir, you need to look it up again. Because it,
Oh, no, no, no. I'm so sorry, Your Honor.
it's a
Different one. I'm
it's a different person.
sorry. That was the previous person.
Oh, you're right. Okay. Well, look, if he can get out, we can just pass it on. We don't need to see whether he has a license.
Okay.
I believe the private counsel that was on the 551 case did file a motion withdrawal. So I do believe he'll need the PD.
You might need the PD?
Yes, Your Honor.
Let's give him a PD then. All right. Mr. Smith, your private lawyer might be trying to get out of the case. So we'll appoint the public defender just in case you need one. Because private attorneys, they, sometimes they do that when they're not getting paid or something and you're having trouble with your license. We pulled up a different record, so can you get out on the $500 bond for the failure to appear? Okay, I'm not going to mess with the other case, but you might have 2.
Okay.
And do you have access to internet?
Yes.
All right. The way you keep up with your court dates is you look them up on the clerk's website. Put your name in there and get past some of the couple little screens and find out your court dates and make sure you go to them. And if you got your license back, show the judges and you probably get the health situation settled. Okay?
Okay.
So bound out on the 500, but just understand you've got 2 that need to be resolved.
Okay.
All right. Okay.
Raymond, Your Honor?
Okay, yeah. So is this Mr. Quoquerlera?
He's medical, Your Honor.
Okay, are these arraignments, this person's been in for 8 days on a no-vow license. And is this one where public defender is gonna waive appearance?
Yes, Your Honor, we do have an offer from the state. Would we be able to reset that if, but he is medical, so that doesn't mean he's gonna be back tomorrow, so we would.
I'm not hearing everything between the mask and you
I'm sorry.
talking down.
If he's in medical, he's not coming back tomorrow, so we can't reset it. I would put it in, enter a plea of not guilty.
Okay, that's on 2021 CT 820AW.
We'll waive the appearance as well.
Pretrial conference date will be June 10th at 1 p.m., courtroom 12C.
Madam Clerk, what division is that? Thank you.
Sorry, thank you. Is this Andrew Gordon?
He's medical also, Your Honor.
He's been in for a long time on a no motor vehicle registration. So he must be in on something else. He can't be in just on this because this is a 60-day maximum that he's been in.
He has 2 cases, Your Honor, and I believe he also has a open felony.
Okay. I'm not sure what division this is at. 81, okay. So we're waiving his appearance and setting the court dates?
And entering a plea of not guilty, Your Honor.
All right, thank you.
Division 81, pretrial conference date is July 2nd, 9 a.m., courtroom 4E.
Okay.
And for the record, that's on 21 CT 472 AE as well as 21 CT 473 AE.
Oh. What's that, this one here? Thank you. Okay, Alberto Madero Castillo.
Medical.
Trying to barcode this. 2021 CT 3398AO. Public defenders previously appointed, it's Division 83.
We'll waive the appearance, Your Honor, and enter a plea of not guilty.
Okay, thank you.
Division 83, pretrial conference, July 6th, 10:30 a.m., courtroom 6C.
All right, Sabrina Perez, 2021 CT 339680. Public defender previously appointed, Division 62.
He's medical, Your Honor.
We'll we'll waive the appearance and enter a plea of not guilty, Your Honor.
All right, thank you.
Division 62, pretrial conference date is June 14th, 9 a.m., courtroom 9B.
Okay, Tamiko Smith, 2021 CT 4098E. I don't see public defender yet on this.
She's medical, Your Honor.
I guess we need to appoint the public defender if we don't already have that.
And we'll waive Ms. Smith's appearance as well as enter a plea of not guilty.
All right, Division 61.
Division 61, pretrial conference date is June 28th, 1:30 p.m., courtroom 6B.
Kevin,
Upton. It's T.O.T. Osceola.
who is that, Aguilar?
Upton.
Upton.
Clayton.
I don't have Upton, so, okay. How about Aguilar, Kelvin? 2002-1 MM2 661AO.
I got him right here, Your Honor.
Okay, thank you. And it's Division 82, public defender previously appointed. It's a battery charge. He's been in for 31 days.
Your Honor, we'd like to enter a plea of not guilty.
Okay, sir, hopefully you've talked to your lawyer about that, so they're going to give you some more court dates on that.
Division 82, pretrial conference date is June 14th, 10:30 a.m., courtroom 10B.
Thank you, Travis Branton, sir. Thank you very much, sir. 2020 MM 4400AO. It's a domestic battery in Division 50, public defender previously appointed.
We'll
It's a
enter,
VOP, Your Honor.
It's a VOP.
we'll enter a denial, Your Honor.
All right, well, sir, we're going to end up giving you a hearing date on that.
VOP status hearing will be June 21st at 9 a.m., courtroom 7C.
Is that Div 50? Thank you.
Your Honor, Mr. Branton just informed me of the passing of his wife, and he needs to deal with funeral arrangements. He also has a daughter.
His wife
Is there any
passed?
way to have a bond set so that he can attend to those affairs?
So, Mr. Branton, you just said your wife passed.
Yes, it was my
Okay, so, all right, you don't need to say much more. That situation is important, and there are a couple of ways to get that information to the judge that needs to make a decision. If you have any family member who can call, there's the public defender's office for one, and there's also the jail chaplain sometimes used to deal with those situations. I don't know if they still do. But they're probably going to be looking for a fax or a scanned document that corroborates this factor, which is important. Then they're going to get it in front of, is it Judge Shoemaker now? So
Yes, Your Honor.
there's a
Shoemaker.
judge that deals with your case, and the one you probably already saw and you'll go back to. But, somebody needs to get it in front of that judge who's going to quickly pull up the criminal history, the facts of the case, corroborate that your wife has passed, and make a reasonable decision. It is an important situation, but the judge has to see those several things in order to make a clear decision. Okay? So you're looking for something like, the medical report, the death certificate, and let the judge make a decision. And the public defender might be the first person that you're going to go for, although sometimes it's hard to get through on the phone lines there. And perhaps this lawyer can assist you by making an email to the lawyers downtown.
Yes, Your Honor, I can do that.
Now, in the meantime, tell your family members to be aware that they're going to need to fax or scan this documentation to your lawyers downtown. Okay, we've got a couple more who I guess are not here. Is Renard Mahone?
Medical, Your Honor.
Okay. That's case number 2021MM33551AO, public defender previously appointed.
We'll waive the appearance, Your Honor, and enter a plea of not guilty.
Division 80, pretrial conference date is June 25th, 9:30 a.m., courtroom 9C.
Thank you. And Shytel Thompson, 21MM2958AO, public defender has been appointed, Division 63.
Medical also.
We'll waive the appearance, Your Honor, and enter a plea of not guilty.
Thank you.
Division 63, pretrial conference is June 10th, 1 p.m., courtroom
Right, we've got some, bringing in some misdemeanors from, I guess, right, is this Ms. Crystal Anderson? That's the next case I have. Are you bringing in misdemeanor pleables?
The Creole interpreter.
Oh, well, we've got the interpreter cases.
We can try calling her. We're not sure if she made it upstairs or not yet, so.
Okay, was that back on domestics? All right, so we're back on domestics. And is this Ms. Pierre then? Wait, now everybody's moving around. Okay. All right, Marcian and Pierre. Okay, okay. Oh.
Charlotte Ashley.
Try calling him? Okay, so so the clerk handed me the files of Lorenka Marcian and Marie Pierre.
Okay.
I mean, I can call the interpreter, but I'm not seeing a defendant here, so normally I would see a defendant here.
Okay.
Okay. Just wondering what the communication is. So you want me to call the interpreter? All right. And I don't know what you're talking about downstairs. Oh, because the interpreter sometimes comes here? Is that what you're doing? Talk about? Oh, all right, downstairs. We'd have a lot of meetings, so I thought you were waiting for somebody to come up here. All right, is this Miss Marcian?
Good morning, Your Honor. This is Alan Figueroa, Assistant Vice Spanish Court Interpreter.
Okay, I think we're looking for a Creole interpreter. Did you all know that?
Yeah, Your Honor. This is Pierre.
Oh, Miss Pierre, okay. Can you do the Creole interpretation?
I cannot, Your Honor, only do Spanish. Was a Creole interpreter scheduled?
I don't know, but I think we got two that need Creole, right? Do we need to schedule it now, or do you have somebody available?
Let me check right now.
So
Your
the
Honor. We
clerk
have someone
said
available.
something about that the Creole interpreter was going from downstairs to maybe where you're at or something? Okay, that's what she meant by downstairs. Okay, we'll see. We're going to check.
Sure, Your Honor. Give me just 1 second while I'm checking, see if we can get one for you.
Thank you so much. I appreciate that. More. Oh, okay.
Yes, Your Honor. We were able to get a Creole interpreter. It would just take 5 to 10 minutes to have her set up, and you can call back in a few minutes, and we'll have her ready.
Okay. We can do that.
Thank you, Your Honor.
Thank you. All right.
We'll keep going.
Right. So, clerk's suggesting we go to some misdemeanors. What do you think about that? Okay?
Great.
All right. And the first one is Crystal Anderson.
Listen.
It's 21MM. A jail number?
Right.
I don't have a Crystal Anderson.
Ma'am? Oh, you want the inmate number. Is that like the agency? Wait a minute. Where is that agency case number? Where's the inmate number? Where is the inmate number? Oh, thanks. Okay, so the inmate number is 21011-842.
She bonded. Yeah.
She bond, oh, yeah, that's right there in front of me. Thank you, I'm so sorry. Okay, how about Ashley Sherest?
His behavior, Your Honor.
right, case number 21MM3395AO. It's an alleged resisting and trespassing. Not much local history, but some in Massachusetts with liquor and et cetera. Shall we appoint a public defender, counsel?
Yes, Your Honor.
Going to Division 83.
Can pretrial services interview her? Is there a reason why she wasn't interviewed? Maybe perhaps the same reason.
She was in Safe Book.
I'm sorry.
Safe Book.
Safe book? All right.
I mean, she has no criminal history to speak of, Your Honor. We'll waive her appearance, but I would have you consider that in setting bond.
Okay, let me look at it quickly.
Your Honor, she does have a bit of history.
In Massachusetts.
Yes, Your Honor. One being assault and battery with a dangerous weapon that she was convicted of, and a resisting without, which is almost the same facts that we have here. We have a resisting without and a battery, showing a pattern of behavior.
Okay. Okay, it looks like they have the probable cause for the several charges, and they're all misdemeanors. Let's set the 500 on the battery charge, count 3, no contact with alleged victim, separate residence. I wasn't sure if they were roommates.
I believe they are, Your Honor, so I'd ask for a one-time return with law
Exactly.
enforcement.
One-time return with law enforcement to get the things out of the residence, guns, knives, weapons to be put in the custody of the arresting agency within 24 hours of release, and just subsidiary bonds of count 2 trespassing and conveyance, and count 1 resisting officer without violence.
At $100, Your Honor?
Ma'am, 100
At
on,
100?
100 on count 1 and 2, and 500 on count 3.
Thank you.
You're welcome.
Thank you, Your Honor.
Are we looking for Ms. Lee? Thank you. That's 21MM 3395AO. I'm sorry, Ms. Lee is 21MM 3390. Yeah, I was just dealing with a case number. Ms. Lee, let us know if you want the public defender, because you could qualify for the public defender's services.
What do you say?
That if you end up needing the public defender, you qualify for the public defender lawyer to be appointed. And the case is in Division 80. This is just a first appearance where I tell you what the charge is and make sure there's, what the bond situation should be. Are you all trying to resolve it?
Yes, Your Honor, I did convey an offer of an adjudication credit time served and no return. I don't know if Ms. Lee is inclined to take it. However, if she does plea, and when you find PC, I just ask they find PC to resisting without, which is 84302, not the attempted resisting without, which is what was charged.
Okay. All right. All right, ma'am. And let's see, in regard to convictions, does she have anything? She has a Willis arrest in 97. Now, why would I convict a person who's never been convicted? I'm concerned because I'll tell you, understood from a lot of background in county civil as well as criminal, it's hard to rent an apartment when you've got a criminal conviction. So I take it extremely seriously. It's hard to get a job. It's an extremely significant incident in a person's life. And I'm not downplaying it, but, you know, it's an extreme consequence for a person with no prior history. It might be academic. Ma'am, are you wanting to bond out on this, or do you want to, does she qualify for pretrial release?
She initially didn't, but let me check.
Initially did? She's looking again, okay.
Yeah, I just.
So the plea offer's time served. I'm going to check to see if you have to post bond, ma'am. But when they tell you that you got to be evicted, then you just have to deal with it because it is what it is. And I expect to go back to county court and deal with about,
She could qualify, Your Honor.
she does.
She could qualify.
I expect to be dealing with thousands and thousands and thousands of evictions very soon. It does not give me any pleasure, but it is what it is, and the moratoriums are over. You can't put money in the court registry, you're out, period, okay? Do you want to take time served and a couple withholds of adjudication, pay some court costs within a year, or do you want to go to downtown court and talk to them about whether you think, you know, they can prove it or not?
Should potentially qualify for pretrial diversion if she did wait.
Okay. All right, that's a good concept also. Some people, they just, you know, they go, no, I'm not leaving. Well. Counsel, she might qualify for pretrial diversion.
I understand, Your Honor. I'm informing her of the pretrial release conditions as well as how to contact our office to get the attorney to work downtown.
All right. So like, for convenience sake, you could take a couple withholds of adjudication on your record and pay court costs, but criminal charges do have an impact. And alternatively, if you went down to downtown court, you'd be given the same plea offer, or there's a possibility of pretrial diversion, which is a program that's like being on probation. It's extra work, but if you finish it, then the charges could be dropped. Okay?
I wanted the charges to be dropped.
All right, so one way to do that is to go to the downtown court, see if you qualify for the diversion program, okay? And if you do, like I said, it's like being on probation, and they charge you fees and stuff like that, so I'm not saying it's a piece of cake, but, you know, it's hard enough to rent a place or get a job without anything on your record, so pretrial diversion, my recommendation is it would be worth it, even though it's not easy, because it's like being on probation. So let's go ahead and PTR her. We're gonna give you a court date to come to court, ma'am, and ask them about pretrial diversion when you get to court, if you're interested in it.
Yes, ma'am.
Your Honor, I believe she still has possessions at the location she was being evicted from.
Well,
I
here's
wonder-
what probably is happening, ma'am, is that they're probably out on the street, and, you know, counsel, I'll let her go back to try to get her stuff off of the street.
Your Honor, state would just ask for no return except for one time with law enforcement to obtain any of her personal belongings.
I'm just sensitive to the situation. I respect that. Just, ma'am, you can get the stuff, they put your stuff out on the street. You can go back and get your stuff, but don't try to get back in the house, or you'll be right back here and I'll see you tomorrow. All right? Because they'll just arrest you again. I'm sorry.
So, but I can't go back and get it, right?
You can get the stuff, but it's probably out on the sidewalk right now, having been picked through by some of your neighbors. No, I'm just going to tell her to just get her stuff, but don't try to get back in the house. Okay?
So how am I supposed to get it if I don't get back in the house?
Ma'am, they have put your stuff on the sidewalk.
Oh, okay.
That's what happens. Don't try to get back in the house.
Okay.
All right. Unless your landlord gives you permission, but you really have to get out of there. Don't go in the house unless the landlord gives you permission. All right. Renee Ojito? Bonded. Bonded.
We got it.
Oh, Hito bonded. Oh, so we,
Creole's ready.
so we got the Creole interpreter ready? Okay.
And the victim needs the interpreter also.
Okay.
Good morning.
Good morning. This is from the Orange County Jail, and we were needing a Creole interpreter. Are you the person we need?
I'm sorry, Your Honor, I'm having, okay, I can hear you now.
Okay, are you our Creole interpreter?
Yes, I am.
Thank you very much. And we have both an accused and also an alleged victim, both of whom need an interpreter. So I guess you're going to go over the intercom instead of through the earphones.
Okay.
And that means that I will articulate everything sentence by sentence so you can repeat everything in Creole.
Okay. Okay, can you hear me okay?
Yes, I can. And
Okay, perfect.
public defender wants to say something.
Is the interpreter sworn, Your Honor?
Were you sworn in yet today, ma'am? Have you been sworn in?
I have not been sworn in.
All right. Do you swear to accurately translate from English to Creole and Creole to English?
I do. Isabel DeRocha, court interpreter, Creole.
Thank you. All right, is this Miss Marcian or Miss Pierre? Miss Marcian, or
Madame Marcin,
or Madame Pierre, right?
ou c'est Madame Pierre?
Madame Pierre.
Pierre, okay, thank you. All right, and we're going to ask the witness, sir, would you raise your right hand to be sworn in?
Levez main droite, s'il vous plaît.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Est-ce que ou seulement t'es capable de dire la vérité, toute la vérité, rien que la vérité?
Oui.
Oui.
Yes.
Thank you. And for the court interpreter, and the case number is 2021 MM 2810 AO. All right, the allegation is violation of pretrial release, I believe. It was
Ou
alleged,
violation liberté avant procès?
it was alleged, I think, that she came to the alleged victim's home while there was a battery pending.
I'm sorry, Your Honor, it's very echoey and I'm having a hard time hearing, understanding you.
Okay. It's alleged that she violated pretrial release on a battery charge by going to the victim's home.
Lui dit que ou t'es violé et liberté avant procès parce que ou t'es allé la caille victime.
All right, so, sir, are you the alleged victim in this battery case?
Victime là, victime dans cas attaque ça là.
Oui, moi là, oui.
Madam Interpreter, I don't think you could hear his response. Can you please repeat the question?
I have lost audio completely.
Your Honor, may I?
I don't know if you can hear me, but I have lost audio completely. I'm trying to see if there's something wrong with tables or anything.
She lost audio. That was
Right
the
now, I
problem.
do not hear anything at all.
She has technical difficulties.
I'm sorry, I do not hear anything at all.
Okay,
My headset went completely dead.
all right.
I'm not sure if you can hear me.
Should we just, maybe we should call? All right, we'll hang up. Is this like rebooting?
Hello?
Hello, can you hear us now? Hello? Hello? Hello?
I'm connected. I'm not sure if you can hear me.
Yep.
If you can hear me, can maybe the person standing at the podium can wave or something if they can hear me?
She wants you to wave.
Okay, so you can hear me, but I cannot hear you. I see you, but I cannot hear you. Let me ask tech what to do at this point. I'm so sorry.
Okay. I guess we'll hang up and call you again when you tell us it's okay. All
I
right.
can't hear anything at all.
Okay, thank you. Sir, we're having technical problems.
Your Honor, do you want to just continue with our ROR motions?
Yeah, I do. Is this another interpreter case?
It's non-pleables, Your Honor.
Non-pleables, okay. Oh, that's where we're at. Okay, then. Okay, is this Ms. Bowman? All right. This is case number 2019 MM 9245AO.
Your Honor, there was an offer to resolve, convey to defense on this one, and adjudication prep time served, no return to the J.C. Penney.
All right, thank you. All right, ma'am, I think this was in relation to a petty theft case. There was a failure to appear warrant. And I think the failure to appear was this year, a pretrial that would have been on the 29th of March. The bond amount is $1,000. I'm assuming you previously had the public defender appointed, correct? Okay, so the state's offering time served in a conviction, but I would tell you that petty theft convictions are really bad to have on your record, even though you don't exactly have a virginal record. And also, petty thefts can be used to upgrade subsequent theft cases to felonies. If you get 2 convictions, the third one magically becomes a felony, and you magically lose your right to vote, and you can, all that.
As you can see, this is a little bit older of a case, and I have not been in trouble since.
So if, it does get more complicated when you have a failure to appear warrant. It's $1,000. If you want to bond out, then, try to make sure you can get back to court. If you have any questions, concerns about your court dates, you look it up in the clerk's computer, and you can find all the paperwork in relation to your cases. It's just online. Anybody is allowed to look it up. It's public information. So you really, if you have any access to any kind of computer or smartphone, you can find out your court date. So if you want to bond out at $1,000, talk to your public defender and deal with the case, and see if they can still find a witness from 2019. They probably might be able to. In most of those stores, they have everything on video. But, if you want to bond out. If you want to take the time served, it's fine with me. But those convictions are highly consequential.
Your Honor, I believe the offer from the state would resolve all these issues today. Correct me if I'm wrong. And I have spoken with Ms. Bowman about that plea offer. We spoke about the rights that she would waive as a part of that plea, and she understands those rights would be waived. We talked about the citizenship and probationary issues. She understood that as well. I believe she would like to enter a plea to resolve this today.
Yes, ma'am.
Is that what you want to do?
Yes, ma'am.
All right. Then, did you sign the plea form?
Not yet, Your Honor. I think she needs to be sworn, and then she signs.
You swear to tell the truth, whole truth, and nothing but the truth?
Yes, ma'am.
Okay. All right, well, we'll have you look at a plea form if you have not already.
Okay. Oh. Yes.
She wants Ms. Bowman would like clarification, I believe, from the state that when she signs this plea today, that it would resolve not only the underlying charge, but also the failure to appear.
Yeah, anything related to this case, sure.
She just wants, she's just unsure.
Yeah, we don't give you a separate charge for failure to appear, we just haul you in and make you post bond to get out,
Okay, I'm sorry.
because then we have a bondsman helping us get you back into court.
Right. Okay. But I very much appreciate you guys working with me, and I'm really sorry for not coming to court.
Okay. All right, ma'am. Now, I've already told you a couple times about how bad these convictions are. You already, I think, might have had one. So the next time you come to court on a petty theft, you'd probably go into felony court.
Yeah, I don't want to do that.
No, you really don't,
I
actually.
really don't.
And job applications don't look good with these sorts of things on your record.
No, that just happened to me.
Right. If you were on probation at the time, you'd be violated on your probation because of this plea. If you're not an American citizen, you probably would be deported for a second petty theft charge. Do you understand that?
Yes, ma'am.
Okay. Do you understand the rights listed on your plea form?
Yes, ma'am.
And that you are giving up the right to have a trial or a defense on the charge?
Yes, ma'am. Yes, ma'am.
So nobody will have to prove it beyond a reasonable doubt to a jury of 6 people, and the jury would have to be unanimous before they would be able to find that the case was proven beyond a reasonable doubt. Do you understand that?
Yes, ma'am.
And there's not much of anything left to appeal, but the case will be over with. Any questions about that?
No, ma'am, thank you so much. It's been hanging over my head for like 2 years, so.
Okay. I'm just going through the normal questions, okay? Satisfied with your lawyer at this time? Yeah, okay. Not feeling forced or threatened in any way to have to enter your plea?
No, ma'am.
Okay. All right, ma'am, I find that you're alert, intelligent, entering a plea of no contest in a free and voluntary manner. I don't have the factual basis with me, counsel. Does this defense stipulate for the purpose of a plea?
The purpose of the plea, Your Honor, yes.
Okay. So we'll accept your plea of no contest, find adjudicate you guilty of the charge of petty theft, sentence you to whatever time you've got served, at least 2 days, 2, okay? Release you as to this charge. So the court costs, I'm not exactly sure, I think it's $273. There's probably a $50 public defender fee in there too. And then what we do is we give you a year to pay. All right, make partial payments because if you don't pay your fines in this state, we revoke your license. So you might want to get that dealt with. All right. And there's usually no return to that GC penny. And is there any other thing I have to order in regard to petty theft conviction? All right.
We just need prints, Your Honor.
There was a point when I think we were having to suspend licenses and stuff on a petty theft case. And
We're ready for the Creole now. You don't have to call, she's on.
Bye, thanks.
Thank you. I think they're telling me the interpreter's back again.
Hello.
Okay. Can you hear us now?
Yes, yes. Can you hear me?
Yes.
Okay, perfect.
Thank you. Okay. Mrs. Pierre.
Okay, Madame Pierre.
And we already got the gentleman sworn in, I think.
Okay, Monsieur vient à prêter serment.
Yeah?
Can you hear us, Your Honor?
Yeah.
Can he hear? Can you hear?
Vous capable d'entendre moi?
Oui, moi attendez.
Yes, yes, I can hear.
Okay. All right, so the charge, I've misplaced my notes now. The charge is violation of domestic violence injunction by seeing or going to the home of the gentleman.
Okay, accusation c'est violation de l'ordre de protection parce que il était allé caille monsieur.
Sir, could you tell us your name for the record?
Est-ce que vous capable dire nom pour dossier?
Moi, les Wilkins, Fleurville.
My name is Wilkins Fleurville.
Okay, thank you, sir. The prosecutor wants to ask you some questions, I believe.
The avocat l'État voulait poser aux questions.
Pas de problème.
I don't have any problem.
Good morning. What is your relationship to Miss Pierre?
Bonjour, et qui relation gagne avec Madame Pierre?
Bon, c'était madame, ouais.
She was my wife.
Do you recall an incident happening back in April 26th of 2021?
Est-ce que vous songez un bagage qui est arrivé le 26 avril 21?
Oui, j'ai.
Yes.
And do you recall coming to court and it being a condition that she have no contact with you?
Est-ce que vous songez au venu dans le tribunal et te gagné en condition que les pas capté gagné aucun contact ensemble avec vous?
Oui, moi changé.
Yes, I remember.
And has she since had contact with you?
Est-ce que l'été gagné contact avec vous depuis jour ça?
Il était vers la Kala 2 fois. Première fois, et là, la Kala, moi, j'étais allé. Et moi, j'étais allé police, de cas sorti. Deuxième fois, il était allé sans police. Et juste après, c'est lui qui vient les police, vient assister, il passe moi carré les police pour lui.
I saw it at the house. She came to the house 2 times. The first time I saw her and I called the police. And then the second time, I didn't see her. She is the one who ended up calling the police because she thought that I was going to call the police.
Moi, j'ai plusieurs fois dans cas là, moi senti qu'il y a monde qui vient la cas là et c'est lui qui gagne clé en amène. Ça a vraiment fait peur.
There's been a few times that I felt like somebody had been in the house, and I know she has a key to the house.
Ça a vraiment fait peur parce que son monde qui qu'on habitué lever même sur moi déjà. So, bon, ça a vraiment fait peur parce que je pas la vie 2 fois.
It's something that really scares me because she's the type of person that already has raised their hands at me. So it's something that really makes me afraid.
So at this time, you still do not want to have contact with Miss Pierre?
Donc, pour qu'on y a ou toujours pas voulu gagner aucun contact ensemble avec Madame Pierre?
Non, nous pas parler. C'est l'MT well.
No, we don't talk. No.
Thank you. That's all I have, Your Honor.
Okay, c'est ça seulement les gains comme question.
Okay.
Well,
Okay.
what do you think is needed for you to maintain this no contact requirement?
Il faut penser aux besoins pour qu'il y ait l'autre de nos contacts là.
Bon, ça m'a entendu de ça. Madame, moi, son monde qui est habitué à lever mes sur moi déjà, à cause de l'âge, moi, pas jamais voulu prendre chemin la justice pour lui. But c'est lui qui tire les polices pour moi qui fait bagarre arriver juste là, et c'est comme ça pour ça t'est passé tout. Moi, dis mon Dieu, en pile, merci.
Well, my wife is somebody that is already used to raising her hand at me, and I don't want to go and do anything, but I have called the police.
Après, j'ai plusieurs marques sur moi là, c'est lui qui bat moi yo.
I have several marks on me. She's the one who gave them to me.
Yeah, et qu'on habitué même à les couteaux sur moi.
She has pulled a knife on me.
À cause de l'âge, ça va qu'on les dit pour me dire que je vais aller les police puisque c'est madame moi m'a essayé ouais comment que me gara Freddy là que li anti.
Because of her age, I'm not going to go and call the police for her. I just want to see how it can be resolved.
Parfois, il va comprendre comment vous parler avec moi, c'est relais sous tête moi. So moi
She doesn't know how to speak to people. She doesn't know how to speak to me or anything like that.
Il y a une jalousie qui est très haut, qui décontrôlée.
Qui ça?
Il y a une jalousie qui est décontrôlée, même parler ma parole à monde, son problème lié pour lui des fois.
She is so jealous. It's out of control. Even when I'm just talking to people, it creates a problem for her.
Okay, sir, I'm not asking about your life history.
Okay, monsieur, moi pas poser aux questions sur la vie ou en général.
It's a very specific question.
C'est une question très spécifique que moi demandé.
Bon.
Is it sufficient to tell her not to come back, or do you need some additional constraint to make it safe?
Est-ce que c'est assez pour moi dire pas retourner, ou bien est-ce que vous besoin plus bagaille pour ou capable de sentir en sécurité?
Bon.
Bien est-ce que c'est assez juge la dit pas retourner bon côté.
Normalement, c'est pas retourner parce que moi, vraiment peur, moi, peur, même pas retourner.
If she could not return, because I'm really afraid of her, and it would be best if she does not return.
Is it safe enough, now that we've had this conversation, and she's heard that you're willing to come to court, is it safe enough to let her back out on a bond and tell her again not to come back? Or do you need something more than that?
Ok, kounya que nous gagnons conversation ça, que madame la ouais que ou pral venir dans tribunal témoigner à propos de ça qui t'est passé, est-ce que vous pensez li assez si juge la dit pas retourner beaucoup de monsieur, quitter madame la sortie sous bande, ou bien est-ce que vous avez plus bagaille?
Bon, moi, pas t'avouer pour your opinion parce que moi, pas gain que parle pas que pas, son plaisir pour me dire que il y a pas trop qu'un bien parce que son monde malade.
Well, there's really nothing that I would like done more because it's not in my heart to do anything like that, and I would not like for her to keep her, for them to keep her. I'm sorry.
Okay, so my assumption is that you're saying that you think this will be enough now that we've gone through this court hearing and she got arrested, and you're going to be safe enough if we give her a bond.
Donc, ça moi comprendre, monsieur, c'est que ça va dire la kounya, c'est que si nous va madame la on bande pour lui sortir, ok, ou va le sentir en sécurité assez parce que nous t'ai fait audience jeudi à il était arrêté, madame là, il était mis en prison, donc ils comprennent que les besoins étaient bien loin de Oukounia, ou pensez qu'il va lasser?
Bon, pour moi, je pense que l'État s'y pose assez parce que c'est juste, c'est la loi. Moi, par contre, pour lui-même, si que lui-même il peut violer la loi.
For me, it would be enough. I think that it would be enough because, it's the law, but for her, I don't know if she's going to violate the law.
Serta, I'm just trying to make sure that you don't get hurt, bottom line. That's all.
C'est moi vrai sûr, monsieur, que pas de rien qui rive. C'est sous ça ma travail la kounya.
I think I've asked enough questions. Does the state really need to ask?
No, Your Honor, I don't have any questions for the witness.
Okay.
Moi pensais que moi posé assez questions. Est-ce que l'État gagne plus de questions toujours? L'État dit non, il pas gagne l'autre question.
Okay.
Regarding, I agree with Your Honor that bond would be appropriate, according to the witness's testimony.
Dis-moi d'accord que bond, c'est un bagage qui t'a pas approprié d'après témoignage, monsieur.
She was previously let out on $500 bond in conjunction with PTR on the underlying battery DV.
Okay.
Il était quitté la sortie déjà sous un bond de $500 avec un relâche avant procès parce qu'il était fait une attaque sur un monde.
As I stated before, that case came in April, so it's been less than a month.
Ça t'est venu en avril, donc il y a moins qu'un mois.
So regarding her bond for the violation of the PTR condition, they would ask that you either double or triple the bond that she was asked to pay, making it $1,500.
M'a demandé donc pour ou doubler ou bien tripler bond là, côté il était quitté le sorti avant, mettez-le sur $1,500 plutôt.
Hoping that an increased monetary condition will help secure her compliance with the no contact order with the victim.
Et on a espéré que si les besoin de payer plus l'argent pour les capables de sortir de prison, peut-être que ça pourrait le faire réfléchir pour ne pas violer bagaille encore.
Okay. So that's fairly standard. The 1,500 also reflects an increased seriousness because when the court says no contact, those orders have to be obeyed. And he said he thought she had come over to the house even when he wasn't there. It's very important that she understands that requirement to not go back.
OK. Afin de monter quantité l'argent que ou besoin de payer pour bonne, son bagage qu'il faut comprendre, m'a espéré, que la faut comprendre que bagage ça très très sérieux. Monsieur dit que il peur de lui et il pensait tout que il était venu la Cali pendant les pattes là. C'est un bagage qui est très sérieux et même besoin madame la comprendre que il pas supposé faire ça du tout du tout.
I'm not sure if she heard the interpreter because she was also talking to her lawyer. Did she understand everything?
Moi pas sûr que il était en des interprètes parce que il a parlé avec avocat li. Est-ce que il était comprendre tout bagage?
No, she did not hear it all right. Okay, ma'am.
Madam Interpreter, can
Ms. Pierre,
Madame Pierre.
Oui.
I'm looking at you now.
OK, m'a regardé au kounya.
Okay. We're hiking up the bond in order to drive home the requirement of not going back there and not having contact while the case is going on. Do you
Nous
understand
pouvons
that?
mettre bande là plus haut. Vous comprenez, Madame Pierre, nous pouvons mettre bande là plus haut. On a besoin de payer plus l'argent pour ou capable de comprendre, vraiment comprendre que ou pas supposé retourner quand monsieur a du tout.
Est-ce que vous êtes capable?
Pardon?
Madam Interpreter, can you tell Ms. Pierre that if she talks about the facts of the case, it can be used against her?
OK, Madame Pierre, si vous parlez de cas même, vous êtes capable de prendre ça ou pas le dire, saisir avec bagage ça contre vous-même dans le futur. Donc, pas parler de cas même.
Madam Interpreter, can you also tell her that the $1,500 bond can be, if a friend or family can come to a bondsman, it can be about 10% to get the $1,500.
Pour en faire de bonnes à $1,500, si il y a une famille ou bien un ami qui est capable d'aller devant un bondsman, il a besoin de payer 10% de ça.
Your Honor, in conjunction with the no return order and the no contact with the victim, state would ask that you also order that she not be within 500 feet of the victim's residence or place of work.
Et en plus de pas de retour côté moun la yé et pas de contact avec moun la, nous t'a demandé tout que ou pas capable approcher à moins que 500 pieds de côté d'irrité, côté du travail.
Okay, that's another common order, but she wants to say something. If you need to get things out of the residence,
Si vous besoin de prendre quelque bagaille qui n'a qu'à là,
Your Honor, I have two questions. One, is she and the alleged victim work at the same location at Disney? I don't know how employment is going to work if they keep running into each other at work. Also, if she has any materials at the shared residence, would she be able to return once? Law
Did-
enforcement.
did she get a chance to return with a police escort to get her things?
est-ce que vous avez une chance de retourner la caillou en grande fois avec la police pour prendre toute affaire?
Oui.
Yes.
Your Honor, this case is about a month. In a few days, it'll be a month old. I would just make the argument if she had anything at the house that was incredibly important for her to obtain, I believe she would have obtained it already, as it was an order from the underlying case that she had a one-time return with law enforcement.
I was
Di
trying,
kasa gen un mois déjà, donc si te gen kek bagay ki important pour la kala, ou ta pran déjà, ou ta al chercher déjà.
ma'am, when you got out of jail the last time, we told you you could have a police escort to get your things. Did you get a police escort to get your things, or did you never have that opportunity?
Ok, madame, là où t'es dans la prison dernière fois, yo te dit que là où sorti, ou t'es capable de retourner la caillou en grande fois avec une police qui t'a escorté ou, est-ce que vous t'es fait ça, ou bien ou pas jamais t'es fait ça?
Moi, t'ai fait ça, mais,
I did that.
mais, tout bagay qui gen nan kay la, c'est pas mieux, c'est moi qui acheté yo. M'pa ka prendre
But
tout
everything
un
that
seul
is-
jour m'sorti dans prison pour m'boter tout bagay yo qui sort nan kay la. C'est moi qui acheté
Everything that
tout
is in the
bagay.
house, done. Everything that is in the house, it's mine. I'm the one who bought it. I cannot just have just one day or a little bit of time to get in the house and take everything that is mine because I bought everything in that house.
Okay, so
I am not in a position to determine which party has the dominant right of possession at this time.
Di kounya, mwen pa kapab determine ki moun ki genyen plus bagay ou bien moins bagay nan ka la, kounya.
I would ask the gentleman, sir, are you married with this woman?
Monsieur, est-ce que vous mariez légalement avec madame?
Moi, j'étais marié à madame, moi, so jusqu'à présent, nous ne pouvons pas divorcer, même pas remarier encore.
We were married, and until this time, we are not divorced yet, and of course, I'm not remarried.
Whose name is the house in?
Kayla, li en bas non ki moun.
Moi, attendez.
Who owns the house?
Ki moun ki propriété Kayla? Kayla, c'est pour qui est lié?
Kala, c'est son nom, nous tous les deux liés. Mais c'est moi qui t'ai cherché Kala, qui t'ai joigné, qui t'ai mis nos madame là-dedans.
The house is under both our names, but I'm the one who looked for the house and got it, and I put my wife's name on it too.
So, folks, I can't resolve this case in regard to who has the dominant possession rights of the house. If you have a divorce action, talk to the judge.
Ok, moi pas capable de résoudre bagay yo à propos de Kayla kounya qui est-ce qui gagne plus propriété dans Kayla, qui est-ce qui gagne moins. Si nous gagnons en action en divorce, c'est avec juge ça nous besoin parler.
Alternatively, in relation to this case,
pour cas ça même,
talk to your lawyer in the public defender's
Allez.
office. And
avec avocat.
give them a copy of whatever the paperwork is, the deed or what have you.
Ba yo en copie de papier, papier Kayla, titre Kayla, ba sa yo.
Because her position is that she owns the house, his position is they both own the house, and it has to be determined because of the deed, the paperwork, the legal actual paperwork regarding ownership.
Madame lui dit que c'est lui-même qui propriétaire Kayla, ou même monsieur nous dit c'est tous les deux qui propriétaire Kayla. C'est pas qui besoin déterminer dans un cas de divorce pour qui est Kayla y est exactement.
So ma'am, it's just no return and 500 feet away from him. I don't know what to tell you about the place of work right now. I think you need to have very good contact with your lawyer and get into court with Judge Shoemaker to figure out all the circumstances in regard to this case because it's getting complicated. But do not take the law into your own hands.
Madame, ou besoin parler, ou besoin qu'il y ait des bons contacts avec avocat, ou besoin qu'il y ait des très bons contacts avec avocat et aller dans le tribunal devant juge Shoemaker pour nous capables de résoudre ça parce que c'est un bagage qui vient très compliqué, mais ou pas capable de prendre la loi dans main pas ou pas capable d'agir pour contour.
The bond is changed to 1,500 plus PTR with the requirements of no return and 500 feet from him and or the residence.
OK, donc nous changer bond là, nous mettons le kounya sous $1,500 avec et relâche avant procès, ou pas capable de retourner dans cas là, ou pas capable de gagner aucun contact avec moun là, et ou besoin rester à 500 pieds de qui côté li travail et qui côté li rete.
I think we spent about 30 minutes on this case, ma'am. We have to move along, talk to your lawyers with your
Parlez avec
questions.
avocat, madame. Parlez avec avocat. Nous allons passer 30 minutes sur ça. Donc, parlez avec avocat, OK?
Good luck.
Bonne chance.
Thank you.
Thank you, Your Honor.
We might have one more.
Oh, okay.
It's Laurencia Marcian, and it's case number 21MM3398.
Okay.
Thank you. In this case, Ms. Marcian, we can appoint the public defender to represent you.
Dans le cas ça, M. Martien, nous capables bon défenseur public qui pour représenter eux.
They have enough information to file the charge of battery.
Yo gagne assez d'informations pour remplir une accusation de attaque.
Your Honor,
Yes, sir.
there's an updated PTR sheet where she does qualify for PTR,
I thought so. She has no history.
and she's employed full-time at Disney for the last 2 years.
Right.
For your consideration, Your Honor.
I don't see the state objecting, so I think it's okay.
Di l'État pas gen aucun problème, donc moi pas gen aucune objection sur ça.
State has no objection, Your Honor.
L'État pas gen aucune objection, juge.
Given she otherwise qualifies and we don't have victim input here today.
Right.
Nous pas gen victime aujourd'hui, donc.
So he has moved out, but they might have some child custody issues.
Di peut-être ap gen un problème de garde pour ti moun.
So ma'am, normally we require that you not have contact with him until you both have a chance to be in court and establish how you can safely have contact.
Di madame, normalement, nous toujours mandé pour pas gen contact avec victime là jusqu'à ce que nous gen temps pour nous venir devant un juge dans tribunal là et ouais qui j'en nous capable gen contact.
In relation to child visitation and custody exchange, it is sufficient if you have a third party, such as a trusted family member, to help for the exchanges of the child.
Si nous voulons un temps pour nous échanger ti moun et peut-être li assez pour nous gagner soit un ami proche ou bien un membre famille qui capable aider nous et faire échange ti moun yo.
So just don't have any contact, and I'm assuming that he's moved out and.
Your Honor.
Yes, ma'am.
Simplement et nous pas capable gagner aucun contact.
State would still ask for separate residences and a one-time return, just in case he has not moved out. And if he has, then it shouldn't be hard to fulfill that condition.
Okay.
L'État a demandé pour résidence séparée et peut-être pour une grande fois retourner une grande fois au cas que monsieur pas sorti de Kaila.
Also, to clarify, Ms. Marcian, it's no contact, and the state wants to make sure, just in case the husband had not moved out, if you.
En fait, nos contacts, ok, et l'État voulait clarifier au cas que monsieur pas sorti de Kaila, pour qu'on sorti de Kaila.
If he didn't move out, then you will at least be allowed a police escort to get your things out of the residence until you can get back in front of the court and get any conditions modified that you need to have handled.
Si au moins monsieur pour qu'on sorti de Kaila, capable de retourner dans Kaila une grande fois avec une police pour prendre affaire qui appartient à lui et ranger bagage nous besoin ranger.
Understood?
Vous comprenez?
Okay. And one last thing, if you have any guns, knives, or weapons, you would put those in the custody of the arresting agency within 24 hours of your release while the
Si
case
vous
is
gagnez
pending.
si vous gagnez quelques armes à feu, quelques munitions ou besoin de mettre ça yo dans charge police là pendant que cas en suspension.
That was straight PTR, Your Honor.
Yes, sir. Thank you.
C'est relâche avant procès net? Oui, oui.
Okay, sir. Thank you.
Okay, monsieur, merci.
That's it. Thank you so much for your interpreting services today.
You're welcome. Have a good day. Bye-bye.
Thank you.
Your Honor, to clarify real quick, on Pierre, you did the $1,500 bond plus PTR?
I did.
Okay.
Because, counsel, she kept going back to the residence, and she kept saying she needs to get things, and I just think, it's going to keep happening unless we have some supervision. So, do we have Mr. Ojito or a Mr. Haddon?
Had to refuse court.
Okay, are we past the misdemeanor pleables? Because I thought I had one more left, but
Ojito, bonded.
bonded. Okay, well, that explains that, okay.
And Mr. Haddon refused court?
Yes.
Okay. I guess we can look at that real quick. We had the 2002 1MM 2033 and 2002 13385 and 2002 1MM 1693AO was out of bond. Maybe we should appoint the public defender.
We'll waive Mr. Haddon's appearance today.
Okay. The 2033 is a failure to appear warrant on a trespass, and the bond is 1,000. That's in Division 8-5.
They would ask for a no return to the 7-Eleven.
No return to the 7-Eleven. Thank you, counsel. The 3385 is in Division 80. It is another probably trespass warning at the 7-Eleven. And we'll, I guess, leave the bond at 500 on that.
And a no return to the 7-Eleven?
No return to the 7-Eleven.
Thank you.
And then, okay, is that it? Oh, wait,
He has an out of bond, Your Honor.
another trespass.
That is at the Lynx bus station, Your Honor.
All right, 2002 1MM 1693. Okay, and he was that a bonding or was that was a, shoot.
I believe it was a bond, Your Honor.
It says bond amount NA, so I don't know what that means.
I have it as $500.
Oh, ultimately, he might have gotten ROR'd. So, is that for Mr. Haddon?
ROR'd,
He was ROR'd. And I don't know if that was because of a 33-day motion or not.
It wasn't, Your Honor. It was at
Okay.
IA.
So let's go ahead and revoke the ROR and put a $500 bond on that one, and because he keeps trespassing. And appoint the public defender. Thank you all. Is this Mr. Samuel Hunter?
No, Your Honor. Your Honor, he refused court also.
Okay. It's an add-on, I guess. Case number 2002 1MM 3338. In regard to a petty theft charge, the bond set by Judge Jordan was $500 for that. Let's go ahead and appoint the public defender.
We'll waive Mr. Hunter's appearance, Your Honor.
Okay, thank you.
Your Honor, I think the add-on potentially was an error. I don't see any other cases that this would be an add-on to. Therefore, I just ask that you stay the bond as set.
Okay, will do.
And a no return to the scene.
And no return, thank you. Is this Mr. Jason King?
Jason King is downtown court.
Okay. Hopefully he's in on this, downtown on this. As it was a failure to appear. Do we know? Should we hold on to this until the afternoon, figure out if they resolved it?
I have no objection to that, Your Honor.
Because he might have had a public defender who might have brought him back in or something.
I believe he had downtown court arraignment on his out-on bond case, that 21 MM 2605.
Right, so that's why I'd rather look at it after lunch, because he might resolve it. And then we'd have conflicting orders, which kind of results in sometimes people being rearrested when they resolve the case.
That's fine, we can take it to second session, Your Honor.
Second session, thanks. Does that mean you guys are going to look it up and I don't have to?
Your Honor, I'm looking at it on the clerk's site right now. It's now set for pretrial. So I'm assuming he did not take any offers on the 21 MM 2605 case, which was his out-on bond. is set for pretrial on June 16th.
You're asking for no action? I'm still having trouble hearing you through the mask.
I'm sorry.
No action on 2002-1MM 2605AO, correct?
Well, Your Honor, I thought that you were wanting to pass it to see if he would go ahead and plead to these at arraignment downtown.
Well, I mean, I think that we're at risk of doing conflicting things, and that downtown, they're gonna probably get them both dealt with one way or another, and then if we come back after lunch, we look and see what they did, and see if we need to do anything else.
That's what I'm telling you, Your Honor. It's already been called.
And you already know, and so you already want to go ahead and take no action on 2002-1MM 2605, correct?
Sure,
Did
Your
they
Honor.
deal with 2002-1MM 2485 also?
No, Your Honor, they did not. It is still set for an in-jail arraignment on the 25th.
All right. So he has a public defender on that. Do you all want to call him back second session, or do you just want to pass him and look at him on May 25th?
Or on May
Uh,
25th, or is that the trial date? I thought it was-
2002-1MM 248580 was a failure to appear. So evidently he got a court date on the trespass charge, and I can't even imagine, well, look, he's already arrested, so presumably they'll send him back here, but
I agree with you, Your Honor, because he's downtown dealing with case 2605.
all right, we're just taking no action pursuant to his in-jail arraignment, May 25th, right?
That's fine.
Okay, thanks.
So
Thank
you're
you, Your Honor.
saying the bond does set, just waiting?
Is the charge?
Yeah, it's a failure to appear on a possession of drug paraphernalia, the bond. Is 500 because of his failure to appear. And let's, if we take no action, if they handled him downtown court, fine. If they didn't handle him downtown court, I guess he'll sit until the 25th.
Understood, Your Honor.
All right, thanks. Okay, Rodriguez Leaks is case number 2002-1 MM 14AO. And that appears to be a failure to appear. Is that you, sir? Okay, a failure to appear, 2 counts. One count being petty theft, one being resisting an officer without violence. It's Division 62. Those had $500 bonds on them because of a failure to appear at a status hearing on April 29th. And I'm assuming the public defender would have been previously appointed. So it's still bondable, but with the reminder that you need to keep up with the court dates, which you can always determine by looking on the clerk's website. It's public information, and you can see the exact court dates if you get confused. Right? Just key your case number in and your name.
I have a moment with Mr. Leaks, Your Honor.
Yeah. Mm.
Your Honor, we have an offer from the state, I believe, to deal with the underlying charges here for Mr. Leaks.
Okay,
It's adjudication of guilt, credit time served, and no return to J.C. Penney. I spoke with Mr. Leaks about the repercussions of entering a plea today, the rights that he would waive, he understood. Also, the citizenship and probationary issues of entering a plea, which he understood as well, and I believe Mr. Leaks would like to enter a plea and resolve these issues today.
okay. All right, then,
I did also inform him of the enhanceability
right,
of pleading to a petty theft as well. I emphasized that, and he still understood.
all right, I see he's got maybe a battery conviction from 2017, but otherwise, this would be the second criminal conviction, so I'll talk to him just a little bit about it.
Your Honor, he also has a 2010 juvenile conviction, but
Which, all right, so, Mr. Leaks, what I worry about is that the petty theft convictions, I just want to be real clear with you about it, because I spent a lot more time in court, probably more time than since these guys were born, over 40 years. So I know that it could affect your ability to rent an apartment and get jobs. Petty theft cases are bad to have on your record, so I don't know what you were looking at when you were talking to the public defender before. Are you okay? Am I making you nervous? It is a nervous thing, isn't it? But I just want you to know that a theft conviction is a very significant problem, potentially. You don't want to get any more of these, and it's just something you're going to have to put distance between yourself and, so that potential employers or even a possible landlord could make judgments about you, and you're just going to have to understand that a theft conviction is not a good thing. You still have a bond. If you had any other opportunity to be on probation for a while and try to keep it off your record as a conviction, but if you want to get it over with today, I'm okay with that. I'm just telling you, it's serious. You don't want to take it lightly. A conviction for theft can have other consequences beyond just, it's a criminal record. It's a bad thing to have on your record. Any questions about that? Do you still want to plead out, or are you thinking maybe bond out and talk to your public defender some more and consider your alternatives? Because you may have alternative plea offers if you really care about your record, like probation or something. Sometimes you have to do more work to earn a withhold of adjudication.
I believe Mr. Leaks would prefer the bond.
Bond out? Okay. So, Mr. Leaks, I'm not trying to make it more difficult for you. I just want to impress on the fact that your criminal record is extremely important, but you're going to have to make sure you come back to court, okay? Number one. Number two, look me in the eye, because it's important. Talk to your lawyer before you come to court, because I know it's a hassle to get through to the public defender's office by phone, but, criminal convictions for theft are extremely important. So if they have any chance at all of getting you a better resolution than a conviction, I don't know if they do or not, but if they do, it might take some work on your part, like probation, which is very, hard for someone who has trouble making it to court on time. But you might want to at least consider it before you do that to yourself, get a conviction for theft. Okay? I would feel better if you think about it, because I've seen people have trouble renting apartments and getting jobs over this. So take it seriously, think about it. If they offer you something like probation to get a withhold, that's something for you to seriously consider. And just never, ever, ever come back to court again, because you get enough stuff on your record that it could mess with you for a long time in terms of getting the kinds of jobs that you really want in your life. All right, so bond out, but make sure you come back to court and do talk to your public defender beforehand.
Your Honor, you're staying both bonds at 500, and state would request a return to JCPenney.
And don't return to that store, okay. All right.
Thank you, Your Honor.
You're
I
welcome.
believe you convinced him.
Did I put this one aside? Because honestly, I don't know which case I've
No,
got.
Your Honor, this, he was our first case from earlier this morning. He was in it, what? We don't need an interpreter. I mean,
Even the clerk doesn't know which case it is, right?
no, he's a Rene Velasquez Lopez.
Yeah.
While downstairs, they just needed him to be brought back up because he has an ICE detainer. And they want him to be held all the way till tomorrow.
They want him to what?
Advise him that he has an ICE detainer.
Oh, okay. And we did not need an interpreter?
I think he understands. He understands.
All right, so, well, she just told you then, if you have an immigration hold, I can't remember off the top of my head what we did for a bond.
Your Honor, we did PTR.
We did PTR, okay. But having an immigration hold it's a complicating factor. I'm not sure what to tell you about that. If for some reason you do get out, then you need to talk to not only your lawyer on the case that you just got, but also you might want to talk to an immigration lawyer when you get out, if you get out. You might not be able to get out because of the immigration hold. All right. Okay, did we finish for the morning?
Yes, Your Honor, we just have ROR motions.
Okay. All right, and it doesn't look, well, we have a few then.
I'm ready whenever you are.
Okay, I'm ready. I think I'm just calling out the case number for you. Jeremy Smith,
you have Smith
21
first?
CF 3301.
Notice and on filing. Attorney?
Tyler Brands on behalf of the Office of Public Defender.
Which case? Oh, hi, how you doing? Which case are you here for?
I'm here on Ivan Lopez.
Okay. The clerk wants to call some Spanish interpreter cases, I guess, to get, you bring Lopez up first, or which? They want to do after the Spanish.
No, he's not getting, my client's not getting a bond. We're just gonna stay it. He's set for tomorrow for a bond hearing in front of Judge Lewin anyway, so.
So you want me to just pull out and stay a bond on something? Did you tell the clerks which one it is?
It's Ivan Lopez.
Lopez, is that?
He's at no bond. He's a violent felon under special concern. So I worked with him on bond today.
It's a VOP, Your Honor.
Oh, okay. Oh, I see. That'll be down there a little ways. Oh, you moved him up? Okay, oh, you had him just past the, no? Here it is. Okay. All right. And he's not here and he's probably in line, but you don't need him to listen to what you're doing right now because they have it stacked up the way they want it.
Right, I don't need him.
Okay.
I've already instructed him. He understands that he's not getting out today and will be in front of Judge Wooten tomorrow.
Right, okay, so this is 2818 CF 11797 Division 20, and it's a violation of probation, no bond on an aggravated stalking. So, okay,
Okay,
leave it. Thank you so much.
thank you. Have a good day, Judge.
All right, nice to see you, okay. You're growing up. I mean, I know everybody from when they were little, young. Yeah.
That is true. I had Jorg over me all the time when you used to be on the bench.
Yeah, yeah. All right, take care. Oh, other way? Okay, good luck. Okay, interpreter. Okay.
Good afternoon, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has already been sworn.
Thank you so much. We have Mr. Santos Sanchez here. Let me run through this deck. Okay. We have case number 2021 CF 5879 AO Division 17.
And we should be appointing a public defender. Okay. And the allegation is aggravated assault with a firearm. I'm just looking at the criminal history better now. And they have him originally set at no bond. Looking at the factual allegations, allegedly, he showed a firearm, threw his hand up. There were some circumstances in regard to him acting or posturing aggressively, but it wasn't like he pointed it at anybody. So I'm not thinking that this is any kind of a high bond case. Being an assault is a little bit not extremely clear, unless I missed something. I tried to read it a couple times.
Your Honor, on bond conditions, his last conviction was in 1998. He's also been unemployed last year.
He's been what?
Unemployed for the last year. He also recently bought a mobile home. So as far as monetary bond conditions, I would
The
I
biggest,
don't like seeing a client that's already maybe low income having to pay a high monetary bond.
okay, partly what I'm concerned about is it's a trailer park, and somebody told him to turn his music down, and this happened, and the state's going to ask for no contact. They might all be living in a relatively close proximity to each other.
Yes, Your Honor. We could still have no contact. We order no contact for like neighbors at the time. It would just be, the defendant needs to be cognizant if the victim is outside to either go inside or go the other way. So as long as he understands that, and that's the court's order, I don't think it should be a problem.
Okay,
Is there a limit of distance, like 500 feet?
Your Honor, I'd ask that you don't put a feet requirement on it.
in a trailer park, it's hard. Okay, so
Yes, Your Honor.
we're not as concerned about this because, to be honest with you, I'm a little bit concerned about the assault allegation in and of itself. Normally with a gun and an assault, you're worried about it being pointed. In this situation, it's more like just strutting around with a gun, and acting aggravated and throwing your arms up. So it's just, I don't know if it's going to be filed as a misdemeanor or not. We worry significantly, sir, when it's a firearm, because any of us who've ever done any level of criminal work have probably ended up having to represent people on murder charges because you pull out a gun and stuff happens. It's really a dangerous situation. Because I didn't see a really true dangerous situation, because I don't think you pointed it at anybody, I'm going to set it at 1,500. Required that you not have any contact with any of these witnesses. If you see some of them in the driveway, the trailer park, go back into your trailer, do something, just get away, all right? Because if they call the police again, you're going to be no bonding on this. And if you have any guns, knives, or weapons, put those in the custody of the law enforcement office that arrested you within 24 hours of your release for safekeeping while the case is pending. Good luck.
Gracias.
Okay.
Thank you.
Thank you. I think we have some more, one or two or something. This is Mr. Yankier Santos, and the case number is 21 CF 5852. We can appoint the public defender, sir.
Okay.
And this was.
Yes.
Thank you. This was alleged, it was a warrant, but it was alleged that you sold a vehicle with a tampered odometer, which is But, it's against the law. Originally, it came in at $2,000 bond. I think that because of lack of history, the first appearance information where the corrections department indicates, did you indicate he qualifies for pretrial release, right?
Yes, Your Honor.
There's no objection.
No objection. Okay, so pretrial release means you can get out without posting a financial commitment to come back, but you would keep in touch with the jail staff, and they have all that information for you to know how to comply with that program. And then we're appointing the public defender, so you can talk to them, hopefully before your case gets heard in court. Just make sure you come to all your court dates.
Your Honor, the state would ask for no contact.
Okay.
Victim or witnesses and no weapons, firearms or ammunition. It's a felony, Your Honor.
You do that on every felony, even if it's like a selling of a car case?
Yes, Your Honor, generally.
Well, I don't understand how that's logical, so I'm just gonna get that one, but don't have any contact with supposedly the victims. Okay? Good luck. I understand some things may be pretty standard out here, counsel. Is this Mr. Vargas? Yes. Okay. So we still need our interpreter, thank you. This is case number 2021 CF 5873, Division 19. Is the amount of money you put down, the affidavit of indigency, if it's weekly, you might not qualify for the public defender, although I think we generally will appoint the public defender at this moment anyway for you. The allegation is aggravated assault with a deadly weapon and battery. And they have enough information to at least file the charge. It looks like a battery and electric weapon type of charge before, but evidently maybe not any convictions. So, sir, I don't know if this guy was a roommate or what. Because, I had to read it really fast. But we had to tell you not to have any contact with that person while the case is pending, at least until both parties are in front of a judge and can testify that it's safe. As I said, I don't know if you're roommates, if you are, and if you need a police escort to get some things out of the apartment until you can get in front of a judge and convince the judge it's safe, then we can provide you the police escort.
Your Honor, are you ordering separate residences?
Yeah.
Okay.
Even though I don't know what the residential status is. I mean, they could be friends, they could be roommates. I'm not sure. And, I don't actually necessarily get into the determination of who has the dominant right for possession of the premises, but generally the parties can work that out. If you can't, talk to your public defender as soon as possible about getting a hearing to figure out exactly the residential circumstances. If you have any weapons, put them in the custody of the arresting agency within 24 hours of your release. So I'm assuming that's the standard bond amount on that, 2,500. And
They would ask that you stay it, given the allegations in the affidavit.
Your Honor, he is employed full-time as a union, other than an arrest of the unlicensed electric weapon.
I think you're speaking to the desk.
I'm sorry. Other than the arrest, there's no criminal history to speak of other than that of an electric weapon.
He doesn't have much.
He has been employed full-time as well, self-employed as a handyman. Fine.
Yeah, and then, okay, there's one other thing to mention is that the alleged statement was, oh, well, it was a threat to kill if you don't put the bat down, which is conditional, but I think the assault might be justified with this thrusting of the knife back and forth in relation to everything else.
Also found, or the defendant was found with
8-inch knife.
the knife on his person.
Well, I'm not saying it's not PC, I'm just, saying that there's some circumstances that are gonna be discussed later.
Yeah, sure. I'm just, in regards to one conditions, asking to stay what is previously set. It's quite disturbing, in my opinion. The victim allegedly was laying on the couch, the defendant entered and immediately started battering him, or at least that's how the affidavit reads. Including trying to choke him and then grabbing a knife. So for those reasons, I've asked that you stay.
All right, I'll stay the bond at 2,500 on the aggravated assault deadly weapon charge and also 100 on the battery. All the other conditions, sir, hopefully you can remember those, although we've been talking for a few moments. It'll all be in writing for you. Make sure you make all your court dates. Okay, was that it for the interpreter, or is Scaglione also? Okay, thank you so much. You have Scaglione next. Is that a move up? Okay. And that was on the. Okay, ma'am, 1 second. That was the felonies, right?
Not.
Okay. All righty, Ms. Scaglione, case number 21 CF 588380. Okay, I see. All right, ma'am, the new charge is possession of methamphetamine and paraphernalia. The standard bond is 1,000 on the possession of meth and 100 on the paraphernalia. We're going to appoint the public defender to represent you. You do have the right to remain silent. Anything you do say can be used against you in a court of law. Your lawyer is standing up and is going to talk to you first before you accidentally say something on the record.
Aaron?
All right, well, she's got a history of some mental health issues and probably.
I'm okay, ma'am. I take medicine, but I took my medicine right last night before I got arrested because I was going to go to sleep in the corner where the police got me.
Be careful. For one thing, I can't hear you. For another thing, I really am afraid that you're going to incriminate yourself. And
I'm not.
I think you're going to find that we're going to be reasonable here.
Okay.
I know it's hard to be calm,
good.
but we are trying to do the best we can to be fair.
It's not.
This other case, the battery on a security officer, I looked it up and I thought it might have been non-filed when she was ROR'd, and I didn't see a complaint filed after that.
No, I was a pass.
I'm just going to give the state a moment to double check that because
I
she knows I usually don't revoke when there's no charge filed yet.
It was an arrest warrant, Your Honor. We haven't filed an information yet. She was ROR'd on it.
Right.
On the 13th.
Right, so let's take no action on it, but, so we end up with one case with the possession and paraphernalia.
Your Honor, state would request no drugs or alcohol without a valid prescription.
Up for a man that's shitty. I'm ready to just take whatever you're gonna dish me and walk out, please, ma'am. Thank you.
Just the standard bond, ma'am. And
Yeah, well,
the
that's
state-
okay too, but I can't feel that either. But I'm okay, thank you, Honor. Can I leave?
The state wants to add a requirement, no drugs while you're out on bond.
Excuse me?
The state wants to add a requirement of no
I don't do drugs, I didn't have drugs, but thank you. Drugs for what?
non-prescribed.
Okay, but I don't do anything that is a non-prescribed. I take a shot in my butt. I had.
Okay. 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 Miss Album, we didn't do anything other than normal. She's in a really bad mood.
Oh, I'm sorry. Was you talking to me? I'm sorry.
No, well, I thought you might be nervous because she was.
Yeah, it kind of made me nervous at first.
She was freaking out. That was, whatever's going on with her. Okay, so in this case, I think you're already represented by former Judge Blake Cheek on something?
I'm not sure.
You're Miss Albin, right?
Yes.
Okay, so, well, if you're not sure, then he's conflict counsel. Okay, so you got a couple things pending. You've got 2020 CF 8113, and you've gotten arrested for failure to appear at a pretrial on April 8th on a trafficking charge. And that case is no bonded from the original judge. And then also an out-of-county warrant out of Osceola County in 2020 CF 2618, I believe. And those are also no bond in regard to a failure to appear on a possession of methamphetamine and paraphernalia. Now, you do actually have a lawyer who is a former judge, but sometimes when you have a conflict counsel, there's problems with communicating because of the paperwork and how many different offices it gets distributed to. And so when you meet him, he'll tell you what, to expect in regard to your cases and what he's found out so far, as far as him getting all the evidence and discovery underway. But at the moment, you've got a couple of no bond situations, and you'll just have to wait for.
Okay, how long will I have to wait?
Well, all I can tell you is you're represented by extremely competent counsel, but I don't know exactly how soon he's going to see you or exactly when your first court date is. And you do have a couple cases that are fairly substantial going on, so you probably should be patient for a little while. You're getting credit for every day that you're serving anyway. Good luck.
Thank you.
You're welcome.
When will I hear about another court date?
I don't think we have a court date yet. I think that your next hearing, you're going to find out more about that. Okay. Okay, is this Mr. Allen?
Yes, ma'am.
Thank you, sir. This case number 2021 CF 5872, it's going to Division 22, and we can appoint the public defender, sir. They had enough information to at least file the charges of possession of cocaine, count 1, with a bond amount of 1,000, attempted destruction of evidence, count 2, at the bond amount of 100, and possession of drug paraphernalia, count 3, which is also a $100 bond. So it doesn't look like you're qualified for pretrial release on this, but you do have some bonds. You do have a public defender. If you bond out, make sure you come back to all your court dates and also talk to your public defender so you can be well prepared when you come back.
Your Honor, state asked for the condition of no alcohol or no drugs without a valid prescription.
No drugs while out on bond that are unprescribed. Good luck. Is this Mr. Armstrong? Okay, thank you, sir. We have case number 21 CF 5851. Which is an alleged grand theft motor vehicle. It was a warrant that was signed by another judge based upon a sworn statement by the sheriff deputy in relation to, I think, something that happened maybe allegedly April 28th in the vicinity of John Young Parkway, where allegedly you supposedly jumped in a guy's truck and acted like frantic, jumped in his truck and took off on it. And allegedly there was a video, which some of these places have videos outside, these commercial establishments. And I think this is the one where the deputy said, I know that guy, because he steals a lot of cars. So unfortunately, you're well known for your strong work ethic and the wrong profession, but that supposedly is what happened. And it came in with a bond of $4,000 on that one. Did he have an on-view violation, or is it just that he's on probation and this is an add-on? Probably.
This is an add-on, Your Honor.
It's just an add-on, so this is just another case that they found in their stack. All right, good luck.
Your Honor, you're staying the bond?
Yeah.
Can I make that a condition, no contact with the victim or witness?
Okay. Is that lady still out there? Oh, somebody else? It's just loud in there. Okay. Kevin Berry, right? Okay, thank you, sir. This is case number 2019 CF 5290. It's a 2019 case, and I believe that Jaya Balani is representing you on this? Yes, ma'am. Okay, so, well, there was a failure to appear warrant issued in relation to a status hearing from November 23rd, and it's generally those felony judges don't play around, they just put it at no bond. So hopefully Ms. Balani's going to be notified that you're in here and can come talk to you about it and get you a court date.
She's
All right.
taking care of it.
Okay.
Thank you.
You're welcome. Okay, is this Mr. Clerger?
Yes, ma'am.
Thank you, sir. All right, it's case number 2021 CF 5854 is the new case, an alleged grand theft third degree in regard to an alleged bicycle theft, which supposedly a security guard had seen and was able to identify. We're going to appoint the public defender for that. And the bond that's initially requested on that is $500, which,
Your Honor, I don't believe that's in keeping with a third-degree felony, also given his history and also given that he is out on ROR for another grand theft.
right, they filed a charging document on that other grand theft as well.
Yes, Your Honor.
Okay, I was just assuming that 500 is what they're doing now, because,
No, Your Honor, I believe it's generally 1,000.
or, it might depend upon this, whatever. So you just want a higher bond because of the prior histories, right? I will say this, it may or may not help the situation. As far as the release on own recognizance, sir, for the other grand theft, sometimes they let you out of jail because the state's charging document hasn't been filed yet. They filed it subsequently, so I'm going to go ahead and revoke the ROR on that and put it back at 1,000. The state's won a higher bond on the other one because she feels like you got quite a history. Now you got a new case while you're out on the old one. I'm okay at leaving it 500. I think between the two of them, the 500 and the 1,000, you know, there's protection for you coming back to court anyway. The new one is going to Division 16. The old one is in Division 17. I probably don't have to tell you when you have different cases in different court rooms, that you might have to be careful about your different court dates because it starts to get complicated.
I have 2 cases right now.
You have 2 cases. You have one,
Resolved in my last.
sir?
I got that resolved in my last court hearing.
It didn't look like it.
It's not resolved.
No, it didn't, see, here's what happens. I know I looked at this fast, but I've seen a lot of cases over the years. And what I saw was you got released on that because the state hadn't filed its paperwork yet, but they subsequently filed the paperwork. So that case still exists. Even if they let you out, the case still exists. It is not over, okay?
Bonds right now?
Sir?
I have 2 bonds right now.
Yeah, you got 1,000 on the one that you were on ROR because you got rearrested. And frankly, you ought to know with your criminal history that you're at serious risk of getting no bonded for that. Getting a new crime while you're out on bond. But I set it at 1,000 and then the other one at 500. And gave you the public defender. If you do bond out, you've got different court dates with different judges. And if that's inconvenient, you might want to make different decisions.
Your Honor, state would ask for no contact with victims or witnesses and no return to the scene, which is 55 West Apartments.
Okay, so ordered. Good luck. Mr. Colvin?
Yes, can I ask you a question?
We're about to appoint a public defender. Would you like to ask them just in case it's safer?
Yeah.
Okay. Did this one. Thank you. Okay, so another judge found probable cause for grand theft, 3rd degree, motor vehicle.
Your Honor, I spoke with Mr. Colvin as a friend of the court. He doesn't.
Counsel, I can't hear very well.
Right. I spoke with Mr. Colvin as a friend of the court. He does have private counsel in these cases.
Okay.
I believe he said the name of the attorney. I don't know if we can get them on the phone.
Andrew Reeves?
Andrew Reeves?
He's a PD, Your Honor.
Yeah.
Oh.
So, yeah.
He told me Morgan and Morgan. So I was under the impression it was private counsel. I'm sorry, Your Honor.
All right, well,
It's the same case, Your Honor. It's just that more charges were added on after I filled out.
okay, let me look. They do look like similar charges, but they, 1979.
Your Honor, he has a grand theft motor vehicle and a resisting without, and then he picked up this, which is the grand theft 3rd degree, dealing in stolen property. He stole the vehicle, and the vehicle, well, the contents of the vehicle are this case that he pawned.
What did they add some for the contents? Is that an add-on charge, or is it a
It's-
separate grand theft charge?
It's not an add-on charge, Your Honor. It was, he stole the vehicle, and then he took the contents of the vehicle and pawned them.
Allegedly.
So it's,
Is it the same factual sequence, but they're adding additional charges onto the originals?
Yes.
You have the right to remain silent.
I guess it could be considered one criminal episode, Your Honor, but
Okay, so we
not
don't
really.
need to do anything to the out on bond paperwork. He's out on bond. I think the total in case number 2012 CF 1979 is $1,200. And now the new warrant, since the judge probably was not furnished the information that these were just additional charges from the same transaction, bumped it up to 6,500. So how does he end up with two grand theft? Okay.
Your
never
Honor,
mind.
one is a grand theft motor vehicle.
All right, the first one's the motor vehicle.
This one's
and
just a
The
grand
other
theft.
ones are the grand theft and the dealing stolen property, where he pawns them. Okay, all right. Okay, so pawnbroking used to be 2,500.
Yes, Your Honor. I believe so.
All right, so let's adjust it to that. Count 2, 2,500, and count 3, receiving money is 150. Count 1, I'm just gonna put it as 100 because it probably is duplicating some of the stuff in the other case, except that you kind of put yourself in that position when then there's a mess of things that you're taking, you know? You can get more charges that way. And, you know, actually, sir, I'm not too worried about giving you a $2,500 bond on the dealing in stolen property or the pawnbroking charge because it's a separate act. I mean, it might be part of the same thing in your mind, but it's like, you know, first you're taking the stuff and secondly, you're going and pawning it. That's actually technically a separate act. And so, I don't know, I guess you bond it out on the other ones. Probably have to do that one more time, ask for the same public defender. It should get put together in the same division.
Your Honor, state would ask for no contact with victims or witnesses and no secondhand pawn transactions while he's out on bond.
Okay.
Call that number to us.
You're welcome. No, because it's really the out on bond didn't really happen before so much as, it wasn't like he had bonded out before. They just added on from when he did pawn to stuff. So it's really the same group of things. Yeah, it happened around the same time. Okay. Is this Miss Corbett?
Yes, ma'am.
Okay. We have case number 2021-5844, Division 10. Let's appoint the public defender to represent you, ma'am. And they had enough information to at least file the charge of possession of methamphetamine. Bond is normally $1,000. I'm looking to see, I guess you don't qualify for pretrial release because you had some former cases. The state's going to ask that you be ordered to not have any non-prescribed medications or drugs while you're out on bond. Make sure you come back to court for your court hearings and contact your public defender.
You're staying the bond at 1,000, Your Honor?
Yes.
Thank you.
Ms. Edwards?
Yes, ma'am.
Okay. Sir, ma'am, we have a couple of failure to appear warrants, and I think you already had the public defender on both. Is it just a couple? I'm looking at it. It's a couple. It's a couple. Okay, so 2020 CF 5980 might have had some different counts in it. Possession of controlled substance, possession of drug paraphernalia, resisting without violence. And evidently had a status hearing on March 2nd, and it was I think Judge LeBlanc, instead of no bond, and you like most judges would, he gave you a bond of 1,000 on the possession of controlled substance, 500 on the possession of paraphernalia, and 500 on the resisting. So the total amount on that is 2,000. And then the other case is 2020 CF 14460 in Division 17, also with Judge LeBlanc. And that was another failure to appear warrant. Status hearing on May 5th for that one. Possession of, I don't know how to even pronounce that.
MDMA.
Okay. And he set you another bond of 2,000 on that. So you've got a couple of cases with 2,000 each. If you bond out, make sure you come back to your court dates unless you like getting picked up like this. Okay, Mr. Hyacinth, right?
Yes, ma'am.
Okay, thank you, sir. This is an additional charge, I think, maybe to something that you might already be getting held on. It's case number 2021-560AO in Division 20, and it appears to have been, I think, a failure to appear warrant. 3 counts, but you do have the bonds of $1,000 on the possession of cocaine, $100 on paraphernalia, $500 on the battery charge. It was a pretrial conference on the 17th of May, so was he in jail? Counsel, we'll appoint the public defender. I just want to let you know, if this is an add-on and he's got a failure to appear from 3 days ago, you might want to check to see if he was in jail.
Yes, Your Honor.
No, Your Honor, he got booked May 18th, I believe.
Okay, maybe they just got him the next day or something.
I believe so, Your Honor. I believe he picked up new charges and he was booked on those on May 18th, so the day
Okay.
after.
All right. In which case, if you got the new charges and they just, and you violated because you got picked up on a new charge and that's why you couldn't get to court, in that case, in some ways, it's a benefit because you're getting like a buy one, get one free in terms of time credit. You're getting credit for more than one case at one time. But you do have bonds on it, and need to talk to your lawyers about the situations, including your medical condition, apparently.
Is your-
Look, sir, okay. Is this Mr. Jackson?
Yes, ma'am.
Okay. All right, sir. We have 2019 CF 2441. It's an alleged violation of community control on a burglary of occupied conveyance and aggravated assault with a deadly weapon. The allegation in regard to the violation of community control would have been that you were not remaining confined at the approved residence on May 3rd. I'm not sure, but I think that sometimes the community control officers come by to check, and if you're not there, you have to face one of these violations of community control charges. This is out of Division 11, and you do have the public defender.
Your Honor, it's staying at no bond, correct?
Right, it's at no bond when it's a violation of community control, sir, so you're going to have to go talk to that judge about it. Charles Jacobs bonded. And so the next person is Nellie Jara,
Bonded, Your Honor.
bonded.
Jones bonded.
Okay, thank you. Are we going to see Mr. Lewick then next?
He's in the hospital.
Okay. Did the public defender want to be appointed and skip it, or do you want to try to bring it back?
Well, I don't know how long he's gonna be in the hospital for, but we'll take the appointment and we'll waive Mr. Luke's appearance. Lewick.
Okay. All right, in regard to 2021 CF 5727, they have enough information to at least, well, they've, actually, another judge already determined probable cause on a possession of controlled substance. Bond amount is $1,000.
Your Honor, state would ask for no drugs or alcohol without a valid prescription.
There's no drugs or alcohol if not by prescription. He also has a child support warrant out of Duval County with a purge of $750 for the record. Okay. Thanks. Is this Mr. Martinez?
Yes, ma'am.
Okay, thank you. We have case number 2021 CF 5845AO. And we can appoint the public defender on that. Now, the allegation is 4 counts of attempted burglary of a vehicle in which I think it was like a security officer down there at the airport said that they saw you trying door handles on the cars. And then the officer also charged you with loitering and prowling on count 6 and the assault, Leo. I forget what that was.
An attempted kick, Your Honor.
Okay.
Also work there.
Yeah.
Sorry.
Sir, do you want to be careful? Maybe you want to talk to the public defender because we're appointing them to represent you. We can't really just drop the charges or do something right now. We're just determining bond. Although I was trying to figure out why they, were they requesting no bond on this? For a particular reason?
No, Your Honor. I believe that was potentially just a mistake. He is entitled to bond.
Okay.
Well, Your Honor, if I may, I was concerned about the loitering and prowling, if he has the charges of attempted burglary and assault, or the attempted burglary, the 4 counts.
Are you worried that it's a kind of a duplication or extra charge or something?
I believe so, because if there was, I just feel uneasy about charging 2 different charges for the same actions.
Oh, I think,
I mean, if you're
that's
charging them
probably
with
something you
attempted,
want to talk about downtown a little bit. I'm not sure they can't do it because as long as there's some different element, and I guess your argument is that the LP is completely subsumed in the others. And that's a good question, but my initial reaction is it's probably can get away with that. But we'll try to be fair on the bond anyway and argue about the precise allegations and however many, which, you could probably talk about attempted burglary and say, well, this should be 1 instead of 4, But no, they're going to get him for every door handle that they saw him touch. And, they'll figure out what's proportionate and appropriate downtown, I think. And we'll just be fair with the bond. And he, I understood, Mr. Martinez, you told me you worked there and everything. So if this is just a gross misunderstanding of what your intentions were, you talk to your lawyer about it and make sure your version is well represented. Let's see here. I'm thinking if, I forget what the bond schedule is for an attempted burglary, but I got the figure of 1,000 in my mind, and then by the time you, load up the subsidiaries, he'll, you know, have something to deal with, but he'll be able to bond out, especially if he's working. So let's go with 1,000 on count one, 150 on count 2, 3, and 4, the other door handle attempted alleged burglaries. Assault on a Leo, I think that's still a misdemeanor, right? 500, and also LP is 100 for the subsidiary bond on the 2 misdemeanors, count 5 and 6. Now, if you were fixing to say that you work at the airport?
Actually, yeah, I used to work there as an
You-
SI. I
you-
still have my badge and everything.
Okay, so will the state, here, this is relevant. The state's going to insist that you don't go back there.
Yeah, I should have just got trespassed.
Yeah, they would have, well, they trespassed you too, okay?
He trespassed me after I told him that's what he was supposed to do.
All right, well, he trespassed you, and there's another little trespass in this case, so you can't go back there. Talk to your public defender and make sure you come back for all your court dates.
Your Honor, state would also ask for no contact with any of the victims or witnesses.
No contact with the victims or witnesses. That's all we have for right now, sir. Mr. Parrish?
Yes, ma'am.
Okay. So I think you got charged with some burglaries of hotel rooms in case numbers 2002-1 CF 5877 and 5878.
I have psychological complications, ma'am.
Well, you don't have to say anything about it because you might accidentally incriminate yourself, but let's appoint the public defender to talk to you if you need to talk to somebody about it. What,
I
ma'am?
believe one was a hotel room, Your Honor, and one was an employee-only zone at the hotel.
Okay.
The kitchen area, the
All right,
elevator
so
area.
2 separate areas, okay. And then it created a misdemeanor resisting out of 2021 MM 3397. And then the next thing that happened, sir, was that if the officers look up your criminal record and find out that you're on probation, which they believed you were on probation in Hillsborough County, they file what is called an on-view violation of probation. That is that set it up for no bond now, anticipating that you're going to be brought back on a violation of probation on those.
I had to go
Okay?
to Tampa too.
Yeah, because these things will violate your probation in regard to Tampa. So it's a little complicated.
Yes, ma'am.
And the way they got it set up is a originating charge of $5,000 on each of the burglaries. It's a complicated, let's see what his priors are. Felony burglary, probation. Looks like he's got a few. It kind of looks like this is your job. Yeah. Okay. All right. Okay, sir, so let's appoint the public defender, stay the bond at $5,000 on the burglary structure for 2021 CF 5877. That's going to Division 20. Subsidiary bond of grand theft at $150. Then the 5878, given the background and history, I'm okay with $5,000 on that burglary also. A similar transaction, but, you know, that's Division 10. Then find probable cause and leave the bond at $500 on the resisting without violence. That's going to Division 81. Now, sir, you've got a few to deal with, but be patient and they'll try to do something fair.
Your Honor, and
Thank you, man.
no bond on his VOP.
No bond on the VOP, and
And
state wants you not having any contact with any alleged victims or witnesses.
And would ask for a no return to the
hotel.
Embassy Suites Hotel
Right.
on all counts.
But I have a violation of probation here and in Hillsborough?
No. What happens is they just see that if you get a new law violation, they file a violation of probation report on the other one, basically just to hold you until Hillsborough can complete their paperwork.
So am I able to bond out from Orange County right now to go there?
Well, yeah, because if you bond it out here, then Hillsborough would come get you if that's the order in which you want to handle things.
And I did speak to my probation officer about trying to get help. I went to jail for trying to cook a DiGiorno pizza in a guy's backyard at 3 o'clock in the morning. I just did 6 years in prison for that. I wasn't actually burglarizing. I was actually completely psychologically lost and blacked out. So it's just, please take a look at the facts of my cases. They're all similar, including this one.
Okay.
We have Rivers.
Thank you.
His behavior, Your Honor.
Okay. Mr. Rivers has 2002-1 CF 588180. Let's go ahead and appoint a public defender on that. Find probable cause and stay the bond at $1,000 on cocaine possession, $150 on possession of controlled substance, $100 on possession of paraphernalia, that's Division 12. And also find probable cause on 2021 MM 320480. Staying the bond at $1,000 on the petty theft in front of Judge McGinnis, particularly in relation to the prior criminal history. That might be appropriate.
Your Honor, as to 5881, state requests no drugs without a valid prescription, and in regards to 3204, state would ask for a no return.
Okay.
And no contact with victims or witnesses.
Okay.
May the Public Defender's Office also waive the appearance of Mr. Rivers.
Thank you so much, very much. Is this Mr. Sheffield?
Yes, ma'am.
Okay, thank you. Okay, sir, we have a I think it looks like a failure to appear warrant, sir, on 2020 CF 1206080. And you already have a lawyer in Division 10. Have you met Blake Cheek?
I'm sorry?
Have you met your lawyer?
No, ma'am.
Okay. So the original charge was a battery with 2 prior batteries, which bumped it into the felony court. There was a pretrial hearing on April 6th, and so it's sitting at 0 bond at the moment, but I think what will happen is the lawyer who was appointed to represent you will get the information and will make sure you get a court date relatively quickly. There's a note about state probation, but I'm not sure that I've got any paperwork on a state probation, just the battery. All right? Good luck to you, sir. Okay, Mr. Stegard? Thank you, sir. We have a case 2021 CF 5875. In Division 20, we can appoint the public defender to represent you. And there's probable cause for possession of a drug, I think they call Molly, with a bond amount of $1,000 on that. If you do bond out, make sure you come to court for your court hearings. If you want your lawyer to be prepared, we'll give you their address and phone number to call them.
Our state would request the drugs with a valid prescription.
Okay?
You had private counsel, Your Honor?
Mr. Stevenson does?
No, Mr. Staggard.
Mr. Staggard?
I didn't hear us get appointed. I assumed he had private counsel.
Appointed the public defender.
Okay.
Okay.
Stevenson bonded.
Stevenson bonded, thank you. All right, is this Mr. Torres?
Yes, ma'am, it is.
Thank you, sir.
Thank you.
This is case number 2020 CF 1093580. You previously had the public defender. There's a no bond warrant because of an alleged failure to appear on the cocaine charge allegedly for a status hearing on March 12th, Division 14. So generally, the case will either go, along the normal time period, unless your lawyer somehow can get you in a little earlier. Each court division has their own methods for that.
Okay.
But at some point, you'll go to court and deal with the case. That's all we have for you at the moment.
Okay, thank you.
Good luck. Is this
Good afternoon.
Mr. Wade? Yes, sir, thank you. We have a couple of failure to appear warrants, sir. One is a 2018 felony, 2018 CF 1718380. You already have the public defender, and it's in Division 10. And it was originally a carrying concealed firearm and resisting. There was an alleged failure to appear for a pretrial conference on December 10th of 2019. And so you have a no bond on that one. The other one is a 2019 misdemeanor, 867580. That is a failure to appear on a resisting an officer charge and trespass in Division 61. In the bond on the resisting is at 750, and the bond on the trespass is 100. So you have the different charges, and make sure you try not to mix them up. If you get out on the felony, somehow make sure you come back to court on the misdemeanor also. Otherwise, they'll just bring you around to the various court dates, and you can deal with them that way.
Yes, ma'am.
All right. Ms. Willis?
Yes.
Okay.
Hey.
Hello? Ma'am, you have a, okay, this was, the new one is allegedly 2021 CF 5871 in Division 10. Allegedly a speed stop in traffic, and officer said you tried to walk away and then you swiped at his camera on. They're probably going to be able to justify at least filing the charge of Bat Leo and resisting on that. And it's a little complicated with this supposed Bat Leo and resisting from a while back when the officers were trying to arrest a family member. Because you've got that pending. And the other one's 2,500. I guess that's what they're doing on Bat Leos now?
Yes, Your Honor.
Okay.
State would ask that you say the current case and revoke and double her out-of-bond case.
Did I appoint the public defender yet?
You have, Your Honor.
She got 5 dependents. Holy cow.
He's been unemployed for a number of months as well. I inquired with the state about the 2020 CF 8852. It is set for trial, but there's no date. So I don't know, it must be pending.
Well, trials are backed up.
Yes.
I believe it's currently on the trial list, Your Honor. That's the last note I have.
You mean for the next month or so?
That's the last note I have in our system as well as the clerk system. It's on the trial list.
Yeah, I don't even,
With no date, they don't have nothing.
There's no date certain, Your Honor. It's,
oh, that's what you mean, a trial list is just this
that's what we've been doing since COVID.
rolling them?
The admin judge puts them on a list and just randomly calls them.
And she got, okay. Well, we usually do double them, ma'am, and you got some background here too. I mean, it's starting to get complicated. You don't have to say anything about your case, but the normal thing, this, why I bet the camera is pretty small.
Your Honor, there's also an allegation in that one that she struck him in the face with the palm of her right hand.
All right. I will stay the bond at 2,500 on the bat Leo and 150 on the resisting. Ma'am, normally when you get this, especially when you get the same kind of charges, we'll double the old one. So on 2020 CF 8852, we'll revoke but double to 5,000 on the bat Leo and 1,000 on the resisting. And my heart goes out to you with all those kids that you're trying to support, but your history as well as what's currently pending would suggest that you might want to get some anger management counseling, especially in relation to cops. I'm not sure what's going on with you, other than you're frustrated by having 4 kids, but. And I guess it was your uncle that got arrested or somebody. Might have been upsetting. All right. Good luck, ma'am.
Thank you.
You're welcome. Is this Mr. Dumas?
Yes, ma'am.
Okay. Sir, this is an alleged violation of community control on a 2019 case, 2019 CF 4189BO. It's alleged that you were away from your approved residence on May 10th. As best I can tell, they go and check your residence sometimes, and if you're not there, they violate you, and then you have to go back and talk to the judge in Division 20, because they no bond you on those. So that's where you're at. I don't know how many days it'll take to get to see the judge, but you got to talk to the judge about staying home when you're on home confinement, or community control, or whatever they call it now. All right.
Hey, ma'am, do I have to talk to the judge about switching my probation officer over to another one?
I don't think the judge has jurisdiction to tell the probation department what to do.
Because I was supposed to be going to work at another job, and she told me that I have to talk to the judge about working at a second job, and she denied me working at a second job.
Well, yeah, you could talk to the judge about wanting to work a second job. And the judge could make explicit directions that you're allowed to, because the probation officer or the community control officer isn't necessarily going to, they don't have authority, I don't think, necessarily to extend whatever orders they think are on the paperwork. And, or even if they did, and you want the judge to be more clear about it, you can talk to the judge about that. Now, the other question about, changing your probation officer, if I heard the question correctly, the judge won't have any jurisdiction to tell the probation office to, change your probation officer.
Well, I mean, because I feel like my probation officer is harassing me, and I would like to get her changed because she's starting to say things that doesn't make me feel comfortable, to the point where I feel like every time she's trying to talk to me, she's trying to violate me for trying to do the right thing and taking the right steps to do the right things. And I feel like that she just doesn't want me to have a second job to make her job easier.
Well, let me just give you some advice, okay? Because really, for the third time, I'm going to tell you that judges don't have any control over probation, okay? I realize that you've got, people with different personality characteristics and probation, and some of them get they just get to the point where they're so frustrated, they just treat everybody the same, But your best revenge, Mr. Hill, is to exceed her expectations and prove her wrong. Okay? If you go and tattle on the judge in front of the probation officer, she's not going to like you.
Your Honor, I believe this is Mr. Dumas.
Mr. Dumas, I'm sorry, I'm reading it. I already had crossed through the case because I thought I was finished, so I was on the next one. Mr. Dumas, don't rat on the probation officer in front of her and the judge, okay?
I mean,
And here's the last thing. First of all, I said your best revenge is to do well despite what you think she thinks of you. The second one is don't be ratting on her because that'll just make her attitude worse. The third one is when you're on community control, you don't have any power. The only thing you can do, how long do you have to do on this? I mean, it was a pretty big charge. You went on 15 years or something on this?
I have to do 2 years on community control, but I want to work 2 jobs because I work.
I understand it.
And she's not giving me the right to do that. So
If you only have 2 more years of community control, you can survive this. But you have to toe the line. If she has any kind of personality conflict with you, you're just going to have to live with it because you don't have any power in this situation. You'd be sentenced. You're like 1 hair's breadth away from prison. Do you understand me?
yes, ma'am.
And you don't want to go there. Promise you.
No, I read it.
Whatever she says to you, smile. She says something, you say, yes, ma'am. And don't aggravate her because you have no power in this situation. Once you're done with community control, sir, you don't have to deal with it anymore, but this is what they call punishment. Okay? And I suggest, just get through 2 years of community control. If you want to work a second job, God bless you. Talk to the judge about it, get your orders clarified, and work hard, play by the rules, and I hope you do well in your life. Okay. Mr. Hill? Okay. Sir, let's see, we got a 2017 case, 2017 CF 10849. It looks like an alleged violation of community control, what used to be a ag stalking case, in Division 16 in it. The community control officer alleges that you were away from your approved residence on the 4th of May when they went and checked, and so that comes in at no bond, and you got to talk to the judge about it.
Yeah, I had went to the Walmart, and when I got back, she told me to send her a receipt. And
Okay.
I sent her a receipt.
Well, I don't know if you kept a receipt, and I'm not sure exactly what the judge requires in terms of proof, but maybe the lawyers can help you on that. Ms. Price?
Yes, ma'am. Good morning.
I'm
Or good
sorry.
afternoon.
I am a little bit blind.
Oh, I thought I was a girl.
I'm a lot blind. I mean, sorry about that.
It's okay.
Okay. We have, they can tell you I'm blind because I've done it before. We have case number 2021 CF 587480 in Division 12. And let's see what we had here. Which I guess is a new case in regard to an alleged possession of firearm by a convicted felon, resisting without violence and possession of cannabis. They had enough information to at least file the charges. And is 4,000 the normal bond amount on that now?
Yes, Your Honor.
Things have been adjusted a little bit. So we'll go ahead and stay the bond at 4,000 on count one, possession of firearm by convicted felon, 100 on the resisting without violence, and 100 on the cannabis. And out of Division 19, what's paperwork on that?
Your Honor, regarding conditions on the 5874, state would ask for no weapons, firearms, or ammunition, and no drugs or alcohol without a valid prescription.
Okay, so ordered. I think there's also a violation of probation, and is that probably not on view, right? So,
It's on view
view,
by the
thank you.
officer.
So, sir, in regard to a case that you have on probation, the 2019 CF 16014,
Yes, ma'am.
when the officer finds that you were on probation and you get a new law violation, he violates your old, it actually is just kind of a duplicate to what the probation officer's going to do, but he just does it really fast, so he can't bond out before they get you on the VOP. So you'll get in front of the probation judge pretty soon, though.
Oh,
But we'll appoint the public defender on that, too. Is that what we already did? Okay, good. I'm thinking there's another whole stack. Okay. Oh, I've had days like that out here, you know, like when I did the weekends, where it never seemed to end. I think one day I had like 120 or something crazy. You seen those? I mean, it's like something out of a dream. They just keep coming. Okay. Is this Mr. Davis?
Yes, ma'am.
Okay, sir. We have a warrant out of Brevard County, case number 2019, is it CT?
Yes, Your Honor.
Okay, 4421. And there is a bond of $5,000 on that. Okay, so it ended up being a DUI, I guess, and a violation of probation with a bond of $5,000. So if you do bond out, you'll have a court date in Brevard County. If you don't bond out, they'll give you a little bus ride over there.
So, what are my choices again? I can either bond out or I can wait for them to come get me.
Yeah,
Um,
and I don't know exactly how long it takes because I'm a substitute judge. It's been a little while since I've been doing this every day. But Brevard is kind of next door, so.
Yeah, it's
usually
an
takes
hour.
about
I wasn't.
It takes about 72 hours, Your Honor.
72 hours, so, okay.
Okay. I wasn't even supposed to be in the county at the time. That's why I got the out of county warrant. I was on the way home and just got.
No, you might accidentally say something that you don't want them to play back at your hearing.
Oh, okay.
Okay. Good luck.
Thank you.
You're welcome. Okay. Is this Ms. Laster?
Yes, ma'am.
Okay. Ma'am, we have a Seminole County case, I believe. And it might be a violation of probation on that for petty theft. And what's the bond on this? Is it no bond?
No bond, Your Honor.
Okay. Oh, violation of probation. So a lot of times those are no bond, ma'am, and Seminole County will just come to pick you up pretty soon, and then you'll talk to Judge Schott about it.
So how long do they have to come?
Well, they won't let you sit over here. I mean, but how long do they?
County comes about every day,
Seminole County comes about every day.
so by tomorrow or Monday.
Okay.
Yeah. Good luck, ma'am. Is this Mr. Smith?
Yes, ma'am.
Okay. Sir, we have a hold out of Osceola County in regard to an active warrant on a petty theft, 2 prior theft charge, and the bond is $1,500. So if you do bond out, make sure you go back to court for your Osceola court date. If you don't bond out, they'll come get you pretty soon.
Ask you a question real quick. I have a petty theft here, so I have a charge here. Will I take care of this charge here before they come and get me, or will they get me first?
Normally, they'll let you take care of this one first.
Right. Okay, so I'll take care of this one first, and then I'll go there. They'll come and get me.
That's usually probably what's going to happen.
Right, okay, thank you.
Okay.
Good afternoon, Your Honor.
Good afternoon. Is this Mr. Vera?
Yes, ma'am.
Okay. Okay, we have, it looks like a Pinellas County warrant
Yes, ma'am.
that you might be no bonded on in regard to what was a battery on a law enforcement officer charge,
Yes, ma'am.
a violation of probation.
Yeah, the VOP was here on a city ordinance, which I'm gonna.
And that's the disorderly conduct from?
Yep.
Okay.
Yep.
And you were out on a bond of $250 for that, and so,
Yep.
but then you had to go to court over in Pinellas, and I think you might have failed to appear at a court date.
No,
No, but they think you did. So that's a problem that you'll have to deal with, because they put it at no bond.
okay, I can bond out here in 72 hours, if you do place a bond for me.
I don't have the authority to do anything to a Pinellas County case.
Okay.
So you do have a bond of $250 on the little one here. I think what I'll do is take no action on it, since it probably did violate you over in Pinellas. So you're currently bonded on that, and that's fine. You won't have a hold over here for this charge.
Okay.
And if they want to come get you, they can do it, but I can't do anything about Pinellas.
Okay, so.
If you prefer to take care of the local one first, then go ahead and do that. But I think being currently bonded out, you don't have to. Take care of this one first. How long does it take to come get you?
Yeah, so from what I understand, I talked to my lawyer and numerous people that you guys have 3 days to inform them, and then they have however much time to come get me.
It doesn't take long.
How could
We'll
I?
notify them today, now that we know that she took no action on your out on bond case. We'll notify them and let them know that you're ready for pickup.
And
It's up to them to let us know when they can come pick you up.
so I have 4 children that depend on me to provide.
Yeah. It doesn't take these other counties very long, otherwise they bring you back here and tell the judge that they haven't picked you up yet.
How long before I can get that done, or should I get? I have Longwell lawyers that represent me on the case that I'm bonded out on.
On the disorderly?
On the disorderly.
Oh, well, they're,
They,
I don't know if they're going to help you in regard to Pinellas, but
is there any way they can push to have you guys can't release me if they don't come get me? Is my question.
if they don't come get you, the jail will bring you back and tell us, Judge, they haven't picked him up. And,
And how
then the
long?
judge, there does come a point where the judge will say, that's been too long. I've released people, but I'm very, it's kind of rare that they take really too long.
What's too long, if you don't mind me asking?
Oh, I don't know, because I'm a substitute. I've been retired for several years now.
I just,
I don't think you, I think you could be in there for, first of all, it's Friday, so you got to deal with the weekend. My guess is you're going to be picked up and taken over next week. Is that a fair guess?
Just about, yeah.
Just about. Pinellas is a little bit further than, say, Brevard. We're used to Brevard or Osceola or Seminole. Pinellas might take a few more days, but, your first problem is it's a weekend, and then, but like she said, she's telling them today that you're ready for pickup, so maybe they'll have it ready within a few days.
okay.
Good luck.
Thank you so much for your time.
You're welcome. Okay. Anything else? All right, we'll be adjourned then. Thank you. Okay.
Judge.